ka ge re le gore rena re NPO gomme ge re lebeletše tša thekgo ya ditšhelete ra lebelela gona teratoropo ya gauteng a re nna tšhelete e lekaneng gore re kgone go tsošološwa ga seo se ke sa dira magareng ga gomme ka nako e teratoropo e be e thirile go rera ka go thuša mekgwa e meswa ya go tlo kaonafatša meago ya ka mo gare ga gauteng yona e be e bitšwa inner cities scheme yeo e be e tla ka meswa ya gore mafelo meago e ka mo gare ga toropo ya gauteng e swantse gore e šomišetswe gore batho ba dule ba kgone gore ba dule pele ka mešomo ya bona gomme Department of Economy ke yona e be e le ka go kereletsa go jwale ge re lebeletse taba ye ya go thušega ga tšhelete ra hwetšela go na le mathata a itšego ao a ileng a re dira gore re feleletše re se ra tsošološa goba ra hlangwa leswa ga kontraka ya rena magareng ga JPC Usindiso ke moo Usindiso.
Deference to my learned colleague, and I have tried to even point out to him that the lease and its terms and its relationship with the community are one completely different. That lease expired in 2020, and there is long discussing. And I was just very nothing to do
Indeed, Abesina did raise issues with me, and I didn't disagree with him for the following reasons. The sentence to explain the circumstances that led to its surrender, and I'm using my very its surrender of its building in 2015. Why did we surrender our professional building? What was our expectation to be able that we in charge of the building between 2003 and 2018. So it was our expectation that whoever is in there is taking care of this building. So that's why that check must be put as record. It's not like, because there's been an insinuation that owners of the buildings just abandon buildings. So we need to explain to the chair what led to us surrendering possession of the building, what was our expectations, so that by the time we come to what happened in 2023, the context is set up. Because by the time the build happens in 2023, already certain things were now out of our control. But at some point we were in control, and this is what we did. That's the reason why we spent time yesterday on this, and we are about to leave in any event the issue of the terms of this lease agreement. But that was the context in which the lease was explained to the chairperson.
Yes, I will allow you to proceed with your line of examination in chief, but as long as you don't spend inordinate time on this aspect.
Thank you, Chair.
Sorry, sir, you
Okay.
have to.
I said the lease expired in 2013. In 2015 and 16, there were payments that were made by the NGO to JPC as part of their rentals. The question that I asked was, what was the relationship what was your attitude towards the NGO during that period of 2013 and 15 and 18, and your expectations as to what must happen in that building?
Thank you, Chair. Normally when a lease expires and we don't renew it, because there's certain other elements that have stepped in, and we allow the occupant to remain on a month-to-month basis. And they would then be expected to continue paying us, and to still look after the building. Secondly, it's, if somebody's in occupation of our building, we want them to continue to pay rental of that building. Whatever the terms and conditions were, they must still look after the building. Their main aim here was to have a shelter for the vulnerable women and children. And so the relationship was still there.
Got it.
I think, Chair, if I can say that, if I watch the payments being made, two in January 2015 and one in September 2016. So obviously the client, the lessee, was not good at paying and keeping up with these payments. And so when that happens, that's how we monitor their financial capability. Ideally, he should be paying every single month.
Correct. All right. Now, we now know that in 2018, you say in paragraph 38 that you started receiving complaints about this building. External complaint that the building was no longer being used for the purpose for which it was intended. You say that in paragraph 39. Can you see that?
Yes.
Now, on paragraph 41, there's an intervention that the JPC makes when it goes on site. Can you just explain to the chair what happened there?
So, even if we lease a building and hand over the responsibility, as you noticed in that lease agreement, and you would see in other lease agreements, when we get a complaint, we have to go and see what the complaint is. The complaint could be about activities in the building, or the complaint could be about, the building's not being repaired. But we, as JPC, would then have to go and look at the building. In this case, the JPC stakeholder manager, who works in Region F, then got to the building and observed that there were security personnel manning the front door, and then he requested to gain entry for the purpose of investigating the complaint.
Correct.
So we will investigate any complaint that comes to our attention.
Yes, and then in paragraph 42, what happens to that
The
inspection?
security personnel that was manning the door denied JPC entrance after receiving instructions from the owner of the NGO to do so.
Was that security personnel, was it the city security personnel?
No, it was not the city security personnel. It was the security personnel of the NGO.
Correct. Now, we then say that in some time after that incident, with the assistance of JMPD, you then gain access to that building. Now, I can just explain to the chairperson then what happened upon us being able to gaining forcible entry into this building.
Okay, so then we would, with JMPD, and at this point we'd have to be accompanied by our law enforcement department. We inspected the building. There were still women and children still occupied the ground floor. Some of the floors remained vacant, so they would do a floor-by-floor inspection. And I would think, although it's not here, the complaint would about been probably activities within the building and not actually the structure of the building. We noted that the structures remained intact, and the women as well as the children occupied the ground floor. There were other floors that were vacant, and a computer school was being operated from this building. And what also appeared that the occupants were starting to privately lease out some of the rooms to the public. Remember, in the lease agreement, we said in that a particular clause that you cannot sublease without our permission.
Correct.
Now, this puts the NGO in conflict with the lease agreement or with the arrangement that he had with us, be it a month-to-month arrangement. He cannot do certain things without our permission.
Yes. Now, that's why then you see now on paragraph 47 that after you observed what was now happening in the building, that the NGO through Pastor Bradley came to seek an extension of the agreement, and that was refused. What was the rationale for you refusing to extend the lease agreement or arrangement with the NGO?
One is that his funding, he wasn't going to get funding from social development, so he had no mechanism of starting to pay the lease agreement, let alone if we had entered into, renew the lease agreement with him, he would not have been able to pay that rental because you can see from his payments, he's not he's not labeled a good tenant from a payment point of view. The NGO was no longer receiving the grants from social development, which means if he had to do any repairs, maintenance, security to the building as per the lease agreement that we would enter into with him, he would have an inability to do that. So his business model would not have been able to sustain the running of this building, and simply because his funding had been withdrawn.
Correct. Now, it means now in June 2018, we can now pick up that there's a problem with this building. One, not even willing to renew or extend the lease with the NGO. Now, what steps does the city through JPC take? I think if you look at paragraphs 50 to 54, what are the steps that the city takes now to deal with what you now pick up as a problem in 2018?
Sorry, I didn't get that last part. What steps do we take as?
Yes, in paragraph 50 to 54, just explain to the chair, what are the steps that JPC takes once it realizes that, one, the NGO is no longer going to be, we call them a bad tenant as used, and they won't be able to pay their rental, and the province was no longer funding the NGO. What do we do at that stage?
Okay, so at this point, we approach, the city's got its own social development department. So we approach as JPC, we approach development department. Our concern is that there are occupants of this building and occupants that are vulnerable. So if we should, we approach our social development department with the view of transferring the building to them, given that the occupants were abused women and children previously funded by provincial social development. But in this case, we approach the COJ social development department. We also approach Johannesburg, what we call Johannesburg Social Housing Company, Joshco. And Joshco would then, we thought Joshco could acquire the building and then convert it into social housing units. Both Social Development in Joshko visited the building, inspected it for purposes of discussing the possible acquisition from JPC or from the city into Joshko's books
Yes.
to convert this building. But of course, these, they both depended on funding from the city for assistance to take over this building. Not just the building and its occupants.
Correct.
So it's not just the building that everybody's focusing on at this point of time. The city is also focusing on the well-being of the occupants of the building.
Correct. Now, but this is a,
ge re tswela pele ka tsela e ya Usindiso re hwetša gore go thoma go ba le mathata ao a hlolago gore JPC e thome go se be le tirišano e kaone magareng ga bona le badudi ba ka mo ge re lebelela letlakala goba paragraph 47 ka baka la mathata a bileng gona Pastor, I don't know whether I'm going to call him correctly, Pastor Bradley or Bradley o ile a leka go tla a boledišana le ba JPC gore a kgone go tšwetša pele ka go lefelela batho ba gore ba kgone go tšwela pele ka go dula felo fao fela ge ba lebelela mokgwa o tšhelete e tšwago go the NPO e be e tsena ka gona ya thoma go ba belaetša mo ba ileng ba feleletša ba sa kgone go dumelelana le moruti ka ge ba lekile ka matla gore ba thušane le yena gomme ba lebeletše gore ba social development ba kgopele thušo gomme ka 2018 ge jwale mathata thoma go gola moramolao o botšiša gore na a lena jwale ka JPC sorry le ile la tšea magato afe ge le lemago gore le kopana le mathata go bahiri ba Usindiso building gomme karabo e tswang go Mrs. Budes e re lekile ra leka go boledišana le bona ra be ra feleletša re tšere magato a go šomiša JMPD gore re tsene ka mogare ga moago ka ge be re sa kgone go dumelelega go ka tsena dilo di bešitše di senyegile ka tsela e leng gore ga re sa tseba gore molaodi wa lefelo le ke mang gomme go ya ka letlakala la 50 to 54 or paragraph 50 to 54 ra tšea magato a mathomo ra re ka ge motho yo a sa kgone go lefelela rente go kaone mohlomong re ka montšha ka mogare ga lefelo le ra be ra lebelela gore motho re ka se kgone go šomiša ko gore ke tirišano mmogo ye le yana o robile tirišano mmogo ye le ya rena ye le re e ngwadileng ka gara koronteraka ya lease ga a sa phethagatša ditshwanelo tša gagwe go ya ka mokgwa rena re kwaneng le yena ka gore ra bona gore bokaone ke gore re swantse gore re gapeletšege re tsene ka mo re hlahlofe lefelo le re bone gore na a go diragalang ka mogaraboraga go tša e le gore go sana le bana go sana le basadi gomme ge re lebeletše ebile go na le o mongwe o botše a computer school ka mogare ga building mola rena re be re tseba e le gore lefelo le ke la batho bao ba hlokofaditšwego bana le basadi ba ba hlokofaditšwego gomme ra feleletša re tšea magato a ra ya go JPC re kgopela thušo social development ra ya go province ra ya go teratoropo ra ya go JOC company le social le go teratoropo ya Gauteng gore re kgone go hwetša thekgo ya ditšhelete gore re tšwetše pele ka go hlokomela batho ba gomme ra bona gore se se a pala ke ge re ta tšea batho ba JMPD gore ba tsene ka mo re kgone go hlahlofa lefelo le COJ le JH company ba tlile ba dira nyakišišo go bona gabotse gore gabotse felo fa go diragala eng ke mora go felela gona.
right. Then that's it. So you're engaging with your sister departments or entities, Joshco and social development, right? What came out of those engagements or attempts to assist the occupants through this JOSHCO and social development?
So from Joshko's perspective, they eventually couldn't acquire the building. As I've mentioned, they did not have sufficient funding. And I suppose they had other priorities in the inner city. So Joshko is responsible for providing social housing in line, and so is human settlements. And they have to provide these housing units in line with the with their list, the beneficiaries on the housing list. So the Joshko engagement falls away, and so does the social development as well. From a funding point of view, they cannot fund the NGO, so therefore the NGO now can't get money from province and they can't get money from our social development department due to a lack of funding. So those attempts, we don't yield any results from those attempts. And what we're left with is the building with occupants in, which we cannot evict, because to do that, we'd have to provide them with temporary emergency accommodation.
Just speaking about that, there's a witness that came in here that owners of buildings, they are using a word hijack, and we'll come to the issue of hijack at a later stage. To say what ordinarily should happen is that an owner must just put a lock, a big lock, on the gates or the entrance of this building and tell whoever is inside that you are entering this building at your own risk. What is your comment to that type of a statement?
So a lock can be removed. Okay. A lock on a building is not sufficient security to secure a building. So a lock can be removed.
Yes, but I think the issue is by not doing that, you are literally encouraging the occupants to continue staying in that building, because by putting a lock, you can just take them out of the building and just put a lock and key so that they must be on the streets. What is your comment to that statement?
So let me get clarity. We must take the people out of the building onto the streets. I'm the owner, the custodian, Sergey being the owner. We must take the people, put them onto the streets, and then put a lock onto it.
Correct.
There's two problems with that statement, is that we're not allowed to, in the period of 2018, we're not allowed to evict people from the building. So taking the people, putting them on the streets is a form of eviction. And we constrained from evicting people from any building.
Just explain to the chair, what do you mean when you say you are constrained or you're not allowed to evict people? What do you mean by that?
We're not allowed to evict them without giving them temporary emergency accommodation. So if we take them out of this building, then the city must provide temporary alternative accommodation in another building. And this is, there's a court order from that ruling perspective. I think we all know that court order, it's public knowledge.
Yes.
Okay. There's also a stay of eviction in the city and a moratorium placed on evictions because of the volume of people needing emergency accommodation in the city during this period.
Correct.
Okay. So by JPC taking the women and children out of the building and placing them on the streets, that would amount to an eviction. Okay.
Okay.
And then we'd have to immediately find a different building or a different place within the inner city to house these people, and there is no such, within the inner city, there's no buildings that are empty. Okay. In terms of putting a lock on the building, yes, that is a form of security, but hijackings in the inner city, our experience with hijackings in the inner cities, they normally hijacked by what you could label a criminal element. And these people would literally break the locks of the buildings, including there's cases where they would even break the burglar bars that are put there. You've just the latest example when the Bree Street debacle, when the city, when the road blew up, when the city put a gate to stop people walking along the streets. The people actually broke that gate and those locks. So the minute it's known that it's a government building, it's always open to an invasion by criminal elements. And I think that's the reality on the ground. That's the reality that we face.
Yes. Now, let's talk about these interventions. In paragraph 65, because you now told the Commission about your engagements with Joshua and other sister departments. Now, on paragraph 65, sometime in October 2018, you advised that some of the residents of the Emma Kloseni informal settlements have forcefully entered or occupied the building. So what was JPC's response to that forceful occupation in paragraph 66 onwards?
So JMPD, so what we...
JPC. JPC, my apologies.
So JPC would then contact JMPD, the law enforcement agency, and we removed the 70 illegal occupants within the 24 hours of actually receiving that complaint. And the reason we try to do it within 24 hours, it's not always possible, especially if we don't have notice of it, but in this case we did. Within 24 hours, because after 24 hours, they then have to stay and we have to find alternative accommodation. So we then remove them, and this is what you call an invasion or hijacking. It's both ways. We started procuring, doing some repairs and maintenance services in the limited budget that we had for the purposes of securing the building. And then we've done some security upgrades, including the installation of burglar bars, gates, etc., which is outlined in paragraph number 68. Additional chains and locks to the doors. But as I've mentioned, our experience is these chains and locks do get, people do break them. And then burglar proofs to the doors and the windows and the ground floors to keep the facility and its occupants safe. But I think in earlier paragraphs prior to this, some of the women that we left in the building also started inviting some of the people from the informal settlement into the building. So the problem started slowly arising and we tried to address it with them.
So you still keep...
So, Mr. Sidumedi, let's allow Mr. Tsatsane to interpret.
Ramola o botsitse potšišo ya gore a dipoledišanong tša lena ge le be le le ka go rarolla mathata a le ile la humana thušo ya mohuta mang go tšwa go bao le bene ba kgopela. Karabo e tšwang go Ms. Botetse ya re ga ra ka ra hwetša thušo go bohle bao re lekileng go ka kgopela thušo go bona. Gomme ra hwetša ile gore batho ba ba dulang ka mo ba mathateng mo e leng gore rena re hweditše pego ye re go nna le batho ba ba sa swanelang go dula ka matsenela ao a ileng a tsenela ka mogare ga moago ba dula ka mo ka ntle ga tumelelo ya rena. Gomme seo sa bontšha gore lefelo le tšerwe ka dikgoka. Re lekile ka mata gore re kgopele thušo go ba JMPD gore re tle re kgone go bona gore na re ka lokiša jwang lebaka le. Potšišo ye nngwe gape ye tšwang go ramolao e rile jwale ka ge le lemoga mathata le be le swantse o ka tshwanelwe le ntšhitše batho ba ka mo gara moagong. Mofumari Botase ga araba gore ka molao ga ra swanela go ntšha batho lefelo leo ba dulang go lona ka gore molao o re ge o ba ntšha o swantse o be o na le lefelo leo o ba išang go lona gore ba kgone go dula ka gore o ba ntšhitše ka ngwakong o swantse go feleletša o ba išitše ka go ngwakong gomme le molao o swantse gore o ntšhe taelo ye e rego ntšha batho bao ka moo ka gore ga ba phethagatše se lena lekwaneng ka sona ra lebelela bontši jwa batho ba ba leng ka moo ra hwetša e le gore ga re na lefelo leo re ka reng ge re ntšha batho ba ra ba iša gona jale re tlo bantšhi jwang ka mo lefelong le gomme re sena lefelo ge re lebelela mafelo ka mo gare a toropo re hwetša le gore mafelo goba meago ka moka e leng ya toropo e na le mathata ka baka la gore go na le mokgwa o o tsweletšego wa go tšea mafelo goba meago ka dikgoka seo se le sa re thuša gomme ra ba ra sa tshwanela ke gore re leke maano a go bona gore na re ka ba ntšha ka tsela ya mohuta mang potšišo e nngwe e tswang gore molao ya re ge re lebeletše paragraph 65 e re botša gore na lena ba JMPC le ile la re ge le lebelešana lebaka le le bona la hwetša gore jwa le maemo a ditaba a eme ka tsela ya mohuta mang ra gapeletše ge mohumane botete a araba o re re ile ra gapeletša gore jwale re bantšhe ka dikgoka ka mo gare ga lefelo le ka ge e le gore jwale lefelo le le fetogile lefelo le re ka le bitša go lefelo la bahlakodi gomme seo se be se dira gore batho ba beng ba dula ka mo ba se kgahlwe ba šireletšegile sa bobedi go tsenela batho ba bantši ka mo gare ga moago gomme moago ga o sa kgona go laolega ka tlase ga mabaka ao ra bitša JMPD ya tla thušana le rena ka diiri tše 24 re kgonne go bantšha ra leka go lokiša lefelo le ka mokgwa re ka kgonang ka gona re lokiša mafestere re lokiša tše ka moka ebile re leka go tswalela a mangwe a mafestere ke ka mokgwa re lekileng go ka rarolola bothata jo.
Thanks, Ra. Now, the penultimate intervention, or the second last intervention that you make, so all this is happening in October 2018 as you testified. Now, just explain to the chair that sometime at the end of October, in paragraph 77 of your statement, you speak of a meeting that was held at CJ Kronje building, all right? And just explain the importance of this meeting and what was the purpose of this meeting in October 2018.
Thank you, Chair. The 2018 is quite a crucial year in terms of the way JPC's the department operates in the inner city. So what we then do in terms of this particular building, because now we don't only have a focus on this building, we have a focus on other buildings in the inner city as part of an intervention of hijacked buildings in the inner city. In this case, we realized that the building's got vulnerable occupants, and that the social development and other city departments have to get involved because the building is under threat of an invasion from the informal settlement. So we hold a meeting with the respective units in the department, social development of COJ, the social benefits unit, CRUM, SAPS, and then the ward councillor, as well as what we call some of the illegal occupants of this building. And the purpose of this building was to see how we could profile the occupants so that we could get them onto the list for temporary emergency accommodation, and how social development could assist with the planning with the occupants of the building in terms of profiling them. Because once we know that the building, we can remove the occupants from the building, the few occupants that were there, then we could move on the building and start working on it as JPC.
Correct.
Hey.
Now, you said in that meeting, it was attended by whoever is there on paragraph 78, right? And in 79, you say that JPC then was asked to request the head office of Social Development to conduct assistance and guidance on how to audit the occupants of this building. Now, was that in paragraph 81? You speak about what social development did.
Yes.
Can you just explain to the chair what was the purpose, and we'll go through the report in the next few minutes about what social development did on the 6th and 11 December 2018.
Okay, social development conducted an assessment of the occupants, and why we would call social development in, because originally when, as outlined in the whole memo, that there were vulnerable women and children in this building. So they have to do an assessment of the occupants, and that's what they actually did. But not all occupants pitched up for that assessment, failed to avail themselves for that assessment.
And this was done 6th and 11 December
11th of
2018.
December 2018.
And in HB 9, you attach a report that was compiled by Social Development as to what is it that they found when they came
Yes.
on site. Now, in terms of the key, we won't go through the entire report, but it's important for the Commission to understand that it is at that stage, what was the understanding of who was in occupation, right? If you go to page 114 of the annexure bundle,
Yes.
that is a annexure HB 9 to your statement. Can you just tell the chair what is that document?
This is the document from Social Development Department, the Social Benefits Unit in Region F, that was present at that meeting of the 6th and the 11th of December 2018, in terms of as they profiled, as what they found in the building from the profiling.
Okay. Now, I want us to focus on the paragraph 4 that deals with the work that they did on that period. Paragraph 4, if you can just read the first paragraph of paragraph 4.
A total of 19 individuals were interviewed and assessed at the Social Benefits Units, third floor CJ Cranier building on the 6th, on Thursday the 6th and Tuesday the 11th of December 2018. Must I carry on?
Yes, please.
The approximate number of people occupying the Usindiso building is alleged to be around 80.
Yeah.
There was no apology tendered for the remaining 61 residents who failed to avail themselves for assessment.
Yes. And overleaf on page 115, the last sentence there. There is also a number.
Out of the 19, that sentence?
Okay.
Out of the 19 individuals assessed, 6 have grade 12, 3 have grade 11, and 1 grade 8.
When I was thinking about, if you go to page 115,
Yes,
are you on page 115?
yes.
On the top paragraph, the last sentence, that is, there is also a number of, let me just
There's
read
also a
out.
number of single mothers who reside in the building with their children despite the inhabitable conditions inside the building.
Yes. Now, I want to go to page 116, headed evaluation. There's a section here that says evaluation. Can you see that paragraph?
Yes.
It says that most of the people assessed fall between band 2 and 3 on ESP. What is ESP? Do you know what ESP is?
Expanded social package.
Right. This would make it difficult to find affordable accommodation, especially within the inner city, with acceptable and affordable accommodation for the family starting at 2.5. Can you just unbundle that paragraph What does that tell you as JPC when you receive this report?
That would mean that these people, if we have to give them if Joshko, I'll just use Joshko as an example, or human settlements, if Joshko had to give them a social housing unit, they won't be able to afford it.
Okay.
So therefore, they're actually without housing. They're without accommodation.
Correct. You go to the next page on paragraph, page 117. The first sentence there is important. Out of the name, you can just read it on the record.
Out of the 19 families that were assessed, 17 did not apply for RDP houses, nor did they apply for any sort of government housing subsidy, as they mentioned that they came from homelands and came to Johannesburg for work opportunities only.
Yes. Now, if you go to the last sentence of the paragraph, it says, this will also affect
This will also affect the decision to accommodate for the TEA.
to recommend,
Sorry. This will also affect the decision to recommend for the TEA, especially if some of the assessed families don't qualify for TEA.
Ntate Tshisane?
ge re tšwela pele ka taba e potšišo e ile ya botšiša gore ka mogare ga lefelo le be le sa tlogele se kgona go laolega gomme go dirilwe dinyakišišo tša go tseba gore ka mogare ga lefelo le go na le batho ba bakae, basadi ke ba bakae, bana ke ba bakae, le gore bao ba ka be ba tsena sekolo e ka ba bakae. Seo gomme se ile sa re ge go dirilwe dinyakišišo ka kgwedi ya ka di 6 between the 6 and the 11 December 2018 ka ke head office ya JPC wa hwetšagala gore mo dinyakišišong tša bona batho ba ge re lebelela letlakaleng la 114 mo annexa HP 9 ga bana ditokelo tša go ka hwetša social benefits ka baka la mabaka ao ba tlileng ka ona. Ge ba dutse ba tšwela pele ba dira dinyakišišo wa hwetša gore batho ba be ba biditše gore ba tle ba kgone go bolaišana le bona, go tlile batho ba ba ka bago 19 gomme ge go lebeletšwe palomoka ya batho ba ba dulang ka mo go tšea gore ke batho ba dulang ka mo ke 80 gomme out of 80 go tlile 19 go gore ka mantšu a mang 61 ya batho ba ga ba tšwelela ge go tlo dirwa dinyakišišo tša go lebeliša gore na thušo ba ka e hwetša ka tsela ya mohuta mang. Gomme ra hwetša gore ge re etla mo letlakaleng la 115 go na le batho bao ba bileng gona ka mo ge re lebeletše taba ye ya dinyakišišo goba re sekaseka thušo ye re ka fang batho ba e bitšwa expanded safe social package. Ra hwetša e le gore batho ba ka mokana ga bona bontši jwa bona ba ka se kgone go thuša ke mokgwa goba tsela ye ya social expanded social package. Joshko e le go ye nngwe ya mafelo ao a kgopetšeng thušo ba hwetša le gore ge ba lebelela social housing unit le gona ba ka se kgone go hwetša thušo ya go ka hwetša dintlo. Ge re lebelela letlakaleng la 117 ra hwetša le gore go na le 17 to 19 ya batho bao ba swantšong ka be ba a ka hwetša thušo ya go ka hwetša di-RDP houses le bona ga bana ditokelo goba ga bana thušo e ba ka e hwetšang gore ba hwetše di-RDP houses gore ba kgone go hwetša madulo ka ge bontši jwa bona ba tšwa magaeng e le batho bao ba tlileng mo Gauteng e le batho bao ba batleng go inyakela mošomo go mo go hwetšala gore go na le TEA ga ke tsebe gore ke ipeletsa ga botse taa mo monna ge šole ke sa tsebe gore era gore taa ye ke sehlongwa seo e reng ge re kopana le mathata a mohuto re lebelele gore batho ba ba leng ka mo re ka ba thuša ka mokgwa o feng ra felelela gona moo re go tša gore batho ba re fa mathata mo e leng gore ga re ka kgona go ba fa thušo ye e nyakegang.
Now, when you go back to your statement, after we deal with the assessment that was conducted by Social Development in December, you indicate that during this process you are still engaging with the department to find mechanisms of dealing with the occupants, but you indicate at that stage that the occupants had become violent towards the JP stakeholder management. Can you see that? Now, just explain then to the chair what happens afterwards. In paragraph 88, you make reference to an occurrence that took place in December 2018.
Sorry, yes, so while we're engaging with the occupants, I think it is in previous paragraphs, some of the occupants stopped responding in an engaging manner, and some of them started inviting occupants from the nearby informal settlement into the building. However, on the 24th of December 2018, 150 people stormed into the building and occupied various floors and rooms on the building. I think if you go to previous paragraphs in the statement, they had actually been threatening at the time to do that.
Correct. Now, you then respond in early 2019, because in this commission I've heard a lot about a blitz that was conducted by GFIS. Can you just take us through that intervention and its aftermath?
So in 2018, after the offices reopened, we then in early 2019, when the offices reopened on the 2nd of January, when the team does an inspection of the building, they realize that the building is now, I have 150 people in it, and that we then contacted our Department of Home Affairs, the Metro Police, the Johannesburg Forensic Investigation Services, GFIS, and they plan a blitz on the building. In other words, the purpose of this blitz is to see who these 150 people are, how do they get into the building, who's occupying the building, etc. It's now called what we would call a invaded and hijacked building.
Correct.
We would label it that.
Meaning as at early 2019.
2019.
You make reference to this blitz by GFIS. There's a report attached to your statement that appears on page 120. Are you there?
Yes.
This appears to be, this is a report dated 31 August 2023 from Mr. Maile Rasesemola, the Director of Property Hijacking and Compliance Investigations. Where is this office located?
The GFIS office is located in the SAPI building in Bloemfontein.
When I was seeing this unit. Is that the GFIS unit?
Yes, sorry, it's the GFIS unit.
Okay.
Reporting to the city manager.
Correct. Now, in this, we won't go through the details of this report. Safe to go to paragraph investigation conducted on page 121.
Yes.
the last sentence before the undocumented, just read the one that says during. During the joint,
During the joint operation, 2 alleged hijackers were identified and arrested by SAPS. A criminal case was then registered with SAPS as per the Johannesburg Central Case 1140/10/2019.
and then
Undocumented foreign nationals on the same date of the joint operation, 143 undocumented foreign nationals were arrested and detained by SAPS and the Department of Home Affairs.
yes. Now, if you go to the conclusion of this report prepared by Mr. Rase Semola, what are we getting there? If you read that paragraph,
It was concluded that allegations of property hijacking were substantiated and a criminal case was registered with SAPS. The docket was referred to the National Prosecuting Authority for prosecution. Upon following up with SAPS, it was found that the matter has been withdrawn in February 2022.
right. Now, here we are at that stage. You have gone there with chiefs. You conducted a blitz. And arrests were made. The case was withdrawn. But now, what does JPC do? First things, let me just put it in this fashion. Was the building still in occupation after this blitz?
Yes, the building was still in occupation after the blitz. So I think it's the numbers actually then go up from the 190, from the 19, or the 150. They then, 19 that we knew of. When JMPD does a blitz, it's now 143.
Before I get to the next segment, I just want that Sani to interpret the last part of the evidence.
Mr. Tsetsane?
go ya ka statement goba sengwalwa sa gago o rile o sa boledišana le batho bao o nyakago thušo go bona gomme go hwetšagala gore batho ba lena ga o dutse go boledišana le batho o le la dirang jwale ka JPC mokhomagadi botetse ga araba gore re be re sa tlhole sa kgona go boledišana le batho ba ka tshwanela gobane ba bešitše ba fetoile manaba go rena ba elwa le rena kore le ge re ka re bolela ka taba efe goba efe e amanang le bona e be ba ntwa ka December 2018 jwale ka di 24 tša December 2018 ge re lekola lefelo le ra hwetša ile gore go šitše go na le 150 people ba ba šitše goba batho ba ba šitšeng ba tšere lefelo le ka dikgoka ka mantšu a mang go bo go sa tle go sa kgona go tsenega lefelo le gomme ra kgopela thušo go JMPD go JF go bohle bao ba kemeng ba kgona gore thuša gore jwale re kgone go rarolla bothata jo ka ge e le gore jwale lefelo le ga le sa tsenega ka di 31st August 20 go ile go ba le poledišano 2023 go ile go ba le poledišano yeo ka yona be re le ka go rarolla bothata jo le city manager gomme ra re ge re kgopela thušo mo letlakaleng la 121 go hwetšagala gore go na le 143 ya batho ba ba tswang ka ntle bao ba tseneng lefelo le ka ntle ga tumello gomme batho ba ba ile ba swarwa molato wa bulwa gomme ka di 22 tša February 2023 go hwetšagala gore molato o getše morago goba o phumutšwe jwale potšišo ya ba gore na ka nako e dilo tše di diragala a go be go sa na le batho ba ba dulang ka mo gare ga lefelo le mokhomagadi botetse ga araba o re go be go sa na le batho bao be ba dula ka mo gare ga lefelo le
Chair, we'll be transitioning into a new segment. I would request if it is an appropriate time for us to have a tea break.
Yes, I think this would be an appropriate time to adjourn for tea. We'll take a tea adjournment for 15 minutes. Mr. Sidumedi.
Thank you, Chair. Ms. Botes, before we took a break, you spoke of the fact that at that time, now in early 2019, there are around about 150 occupants of the building. At that stage, were you able now to access the building?
From 2019, when the building becomes hijacked, from that December, we're unable to access the building. It's with most hijacked buildings, it's once it's taken over by the a criminal element that's collecting the rental, it makes it impossible to access the building.
All right. There are two issues that I want us to address. Even at that time, as JPC, you were still the custodian of the building as part of your mandate. Am I correct?
Yes.
Now, there are various bylaws that the city has. Not only the bylaws, but even at national, there's what you call the National Building and Regulation Standard. Are you aware of that act?
Yes.
Are you aware of the various bylaws that impose obligations on the owner of the building?
Yes.
As an example, are you aware of the emergency services bylaws that require an owner to make provision for certain fire equipment in a building?
Yes.
And many other bylaws that have various obligations that are imposed on the
Yes.
owner. As the city, did you consider yourself exempt from these bylaws?
No, the city is not exempt from the bylaws. We must implement and abide by the bylaws.
Now, the question then is, if you were aware that in terms of these various bylaws, there are certain things that an owner must do to ensure that certain standards are met, why didn't the JPC that is on behalf of the city take those measures?
Yeah, there's two reasons why JPC would not take the, could not take certain measures. One would be, if a building's hijacked, we can't access it to take those measures. Secondly, it almost makes it impossible to access the building as JPC. You'd have to go in with your full law enforcement agencies, in which case, and certainly the occupants of the building, if you put certain equipment in place, do destroy that equipment. And let's say pre the hijacking, we would access the building to put all the necessary, to ensure that the buildings in terms of the bylaws, but also putting up certain equipment in any building. Remember yesterday I mentioned to you the volume of budget that's needed. I think I've mentioned about 434 million is needed that the owner of the building must give us as JPC. We're just the custodian of the building, but the owner of the building, the COJ, must make budgets available to the value of about 430 million to ensure that all its buildings meet the various standards from a bylaw perspective. And budgets, I've pointed out yesterday, that budget from the pool is just not available. But in the case of this building and other buildings that are hijacked, we can't still service and repair the building in terms of those bylaws. So you're making the building, what is an illegal action? By you entering that building, you're making it legal.
Correct. Now, in terms of, I know you have said you are aware of the bylaws, but various sister departments like EMS and the building inspectorate, did they serve any, are you aware of any notices that were served on JPC, either for Usindiso or any of other buildings that are of a similar nature?
Yes, they did serve notices. Where buildings hijacked, we cannot access those buildings to implement those notices. And the only way you can do it is you have to to fix up those buildings. The buildings must be empty because the buildings are of such a state that it actually needs reconstruction, becomes a construction site. It's a whole refurbishment of the building. And so to empty out those buildings, to do what EMS requires us to fix up, to get it in terms of the fire standards, to get a fire safety certificate and electrical compliance certificate, you probably have to do, I'm just giving examples, rewiring of the buildings. You have to empty the buildings out. To empty the buildings out of its occupants, I have to give them alternative accommodation. That's the TEAs that I constantly talk about. So it almost makes it an impossible, a very difficult, not impossible, a difficult hurdle to cross. So if I take this building where notice was served, I'd have to empty out the building of its 150 occupants and then find them alternative accommodation within that particular, within the inner city. And alternative accommodation is not standing, you don't have it readily available. One has to build alternative accommodation or find a building that is suitable for that alternative accommodation. So that's the ideal would be to have this accommodation available, move the people out, and then refurbish the building to the correct standards, and then move the people back in. That's the ideal, but we don't have that. We don't have that emergency accommodation available. We don't have a building of the correct standards available to evacuate the people out of the building, fix up the building, and then move them back. So it's even more of a hurdle compared to the budget, because even for TEAs, you would require a budget. And remember, on the TEAs, there's a waiting list for the TEAs as well.
Maybe let's talk about these TEAs, because we have been speaking about the TEAs without really expanding on that. What is a TEA? Because various documents just speak of a TEA.
A TEA is temporary emergency accommodation. So if you have to, any person that's, you have to move out of a particular building, and I'll give you a building that's this particular building, or I'll give you a building that we're currently working on, Vaneen Court, which doesn't meet any of the standards. And as JPC, we put this building out on tender for private sector to take over the building and to enter into a long-term lease and then to refurbish the building so that we can, to the correct standards. That's what we've done. But to move those people out of that particular building so private sector can take over, we have to find alternative accommodation for them. And in terms of the city's planning done by the Human Settlements Department, they provide the temporary emergency accommodation. Now, temporary emergency accommodation, there also has to be budget for it. The Human Settlements Department has to have budget for their temporary emergency accommodation. This is an example. JPC can allocate a piece of land to them, but that land must be serviced land. It must have its water, it must have its ablution facilities, it must have the basic that's required in terms of the law, and then the housing department will come up and put up a structure. The structure is intended for temporary use, for short-term use. The TEA has also got a list of people that are lined up to go into that TEA. So if in terms of the housing department, they know that they're going to, Human Settlements Department, they are going to empty out this particular building. Those people of that building will be on the TEA list, and they're going to empty out the building to fix up that building. And then those people from that building will go into the temporary emergency accommodation, and when the building is concluded, they start finding their way back. It's a side note, but I think it's important to mention, sometimes buildings get hijacked and invaded so people can circumvent the list process and become top of the list. So it's all linked into the housing waiting list. But TEAs is temporary emergency accommodation, where we move people out of one building into temporary accommodation, and when the buildings are finished, you move them back. Yeah.
Dr. Khosa?
And that is linked to a rental that they then have to pay. And if I go back to the social, to the profiling of people, you have to profile them to see can they afford the new unit that's coming up.
Dr. Khosa?
Thank you. Ake uqhubekile uHoli ummeli ohola ufakazi ngembuzo uMnumzana uSidumedi nokufaka imibuzo ufakazi uNkosazana Bottas. Uqhubeke lapha agcine khona ngokuphathelene nalesakhiwo ukuthi uma uqala u2019 abantu abehlala kuleli bhilidi babe ngu150. Ngakho ubuzile ukuthi njengoba kwakuhlala abantu abangu150 babekwazi yini ukungena bona njenge JPC ukungena ngaphakathi kuleli bhilidi. uNkosazana uBottas ushilo ukuthi kwakungelula neze ukungena ngaphakathi ngenxa ukuthi okokuqala leli bhilidi laselithathwe ngodli bahlala ngenkani abantu kulona. Kanti okwesibili lase linobugebengu ngakho kwakungelula ukuthi bakwazi ukungena kulo ngaphakathi. Ubesebuza manje ummeli ukuthi uyawazi yini ukuthi kunemithetho esebenzayo, imithetho esebenza komasipala nemithetho esebenza kuzwe lonke ephathelene nokwakhiwa kwezindlu ukuthi uma izindlu zakhiwe kufanele zibe njani. Yimiphi imithetho esebenzayo nebeka emahlombe omnikazi wendlu ukuthi umuzi kufanele uma wakhiwe noma isakhiwo sibe esinjani. Uvumile uNkosazana uBottas ukuthi uyakwazi lokho, leyo mthetho ebekiwe yokunakekela izakhiwo uyazazi ukuthi kufanele zihlolwe njalo konke lokhu uyakwazi. Manje ubuzile ukuthi ingabe benisakwazi yini ke manje ukuyithobela leyo mthetho ebekiwe. Izizathu azishilo athi zimbili zenze kwabanzima manje ukuthi bakwazi ukuthobela lemithetho, kodwa okungasho ukuthi ngenxa yokuthi ibhilidi selidliwe ngodli angeke kufanele bona bangayithobeli imithetho. Ngakho kwakusafanele bakwazi ukuthi bayithobele. Kodwa izizathu ezimbili eziyinhloko izona ezenza kwangaba lula. Izizathu sokuqala sibalile ukuthi vele ibhilidi laselidliwe ngodli abantu bazithathela lona bangena ngenkani. Kanti okwesibili kwakungasangeneki ke ngaphakathi kwalo. Ngisho ukuba kwangathiwa bayazama bathobela lemithetho ebekiwe yomasipala yokuthi bafake imshini yokucisha umlilo ukusebenza ngaphakathi bekungeke kwenzeke ngenxa yokuthi uma bengayifaka bekungasho ukuthi lezo zinto abazifakayo ziyatshontshwa kusasa ngoba phela leli bhilidi selithathwe ngenkani. Uze wakhumbuza ukuthi izolo ushilo enye yezinkinga nezingqinamba ababhekene nayo indaba yemali. Ukuze bakwazi ukulondoloza nokunakekela ibhilidi badinga imali yezigidi ezingu430 yezigidi. So ibizovela phi ke leyo mali yokwenza kanjalo? Ngenxa yalokho ke ezinye zezinto okwakufanele bazenze babengakwazi ukuthi bazenze ngokohlelo okufanele bazenze ngalo. Futhi kwakhona ukuthatha imishini ekufanele isebenze bayifake ebhilidini edliwe ngodli kwakungaba nakho ukuphambana nomthetho ngoba abantu babezozithathela lona. Ubuzile ke ummeli uMnumzana uSidumedi ukuthi iEMS ngoba yayikhipha izaziso pheceleza ama notices wafake kulama bhilidi babekwazi yini bona ukuwathola lezo zaziso. Uthi babengakwazi ukuzithola ngoba lezo zaziso zazifakwa kulo leli bhilidi elithathwe ngenkani. Babengeke bakwazi ukungena bayozithola ngoba ukungena kwabo ngaphakathi kwakungasho ukuthi kufanele bathole usizo lwamaphoyisa oluzobangenisa kuleli bhilidi manje elithathwe ngenkani. Kodwa ke uyasho ukuthi enye yezinto ababhekene nazo uma bezama ukulungisa le ndaba ukuthi kufanele okokuqala uma ukhipha umuntu kuleli bhilidi ngoba ukwazi ukuvela ufake kufanele ubakhipha abantu. Kodwa ukwazi ukubakhipha abantu bashiye emgwaqweni. Kufanele ubafunele indawo abazohlala kuyona ngesikhathi usalilungisa leli bhilidi ukuze libuyele esimweni salo. Ubeseveza futhi ukuthi ngalesikhathi ibingekho indawo ekulungele ukuthi bangabathatha abantu babafake kuyona, ngoba lokhu kuvumelana nalokho okubizwa ngokuthi i-TEA. Ubese ngenela kummeli ebuza ukuthi ake uthi ukulichaza leli gama le-TEA olokhu ukhuluma ngalo ukuthi lisho ukuthini. Leli gama elithi TEA limelela u-temporary emergency accommodation, okusho ukuthi indawo yesikhashana umuntu ahlala kuyo ngesikhathi kunezimo eziphuthumayo. Ushilo ke nalapho ukuthi yilokho phela kwakufanele bakwenze uma bekhipha labantu kuleli bhilidi ngokwale TEA, kufanele babafunele indawo yesikhashana abazohlala kuyona. Emva kokuba bebafunele indawo babuyele kuleli bhilidi balilungise livumelane nemithetho umasipala alindele ukuthi ibe yiyo, uma eqeda bababuyisele ngaphakathi. Lalapho bazobe bebeke khona kwesikhashana, akusho ukuthi bababeka nje okhalweni. Nalapho kufanele kube indawo ekahle ezonika labantu amanzi, ibe nenqalazizinto efanele ngesikhathi besalindile. Ngakho konke lokho akukwazanga ukwenzeka ngenxa yokuthi bebengenaso isakhiwo abazothuthela kuso laba bantu ngalesi sikhathi. Ngakho kwayona i-TA lena bebeyazi kahle, kodwa ayizange yenzeke ngenxa yokuthi ibhilidi lidliwe ngenkani, futhi okwamanje alikho indawo abangakhoseliswa kuyo ngesikhathi lisalungiswa libuyiselwa esimweni.
Thank you, sir. Now, after painting a picture about the hijacked buildings, yesterday you make reference to the fact that as JPC, as part of your facilities management, it does not include security. Do you remember that evidence?
Yes, I made that statement, yes.
Who then provides that security services?
There's two aspects to that. If we lease out the property, we ask the lessee to look after from a security point of view. But if we don't lease out the property, then our sister or brother departments, JMPD, is mandated to provide the security. But we have to pay for that security as JPC. So they would go and get a service provider. If they don't have sufficient manpower, which they don't, they will then get a service provider, a private security company, to assist us with security. And that security budget is actually then given to us to say, this is your security budget for the year. In JPC's case, we don't get a security budget. We've not got a security budget for the past, I think, 10 years. Mm-hmm. So JMPD has been assisting us where they can on some of our invasions using their own manpower. But we have to pay them for that security.
Correct. Now, in 2019, and we'll just use this phrase loosely, colloquially, when the building was now hijacked between 2019 and 2023, did you ask or try to elicit or solicit the service of JMPD to provide security service in the building?
Are you talking 2023 before the hijacking? Not before the fire?
Yes, I'm saying we have testified that in 2019, you could no longer access the building because it was hijacked.
Yes.
So the question is did you solicit the services of your security department, JMPD, to assist in this regard?
No, I did not solicit the services, because if I solicit the services of JMPD, the building must be an unencumbered building. It cannot be hijacked. So this building at this point is hijacked. JMPD cannot provide security to a hijacked building.
Okay. Right. Now, here we are. So far, in terms of your testimony, you talk about the buildings hijacked. You have explained to the Commission the challenges that you experience in terms of providing TEAs and the need to empty the buildings, and the fact that you are concerned with the fact that you are bound by these bylaws. We know that in August 2023, there was a crisis at Usindiso where there was a building, the building burned. The question then becomes this: JPC as the custodian of all these properties, including Usindiso, what other measures are they putting in place to mitigate against what transpired at Usindiso and possibly other buildings that are of a similar status? If you go to page 86 of your statement, that speaks about the status of the buildings and interventions there.
So, to answer your question, in line with the statement, JPC, and we started it in 2018, where we, remember I had explained earlier on, between the period of 2013 and 2018, the buildings in the inner city fell under the Department of Economic Development, and they were busy with the program called the Inner City Property Scheme. And that program was an intervention in the city to deal with what we call hijacked buildings or bad buildings in the inner city. It came back to JPC in 2018, where we then said we started actively releasing buildings. When we say we release buildings, we release it for development or demolition. So we started in 2018 with releasing about 100 properties in the inner city, between the inner city and Orange Grove, to the public sector. Because in the absence of funding from government, we then said, let's go to private sector and partner with private sector to take over these buildings and to redevelop them for housing purposes in line with the city's plans. It was the first attempt it was the first attempt of the city to actively work in the inner city. The program started in 2018. We released it, actually started prior to 2018 with the planning. It started around about 2015.
Yes.
And this inner city, even before 2015, this inner city property scheme was one of those programs. It then evolved into what we called in 2018 into the inner city property release program. The city's got, the city as the owner of properties and in its attempt to fix up the inner city has put in a number of plans in place. The 2018, and they started working on these plans since 2011, if I recall. And they started slowly. In 2018 was the culmination of releasing some of these buildings to private sector. Now, one must remember that private sector must have the ability, those people that respond to those properties must have the ability to raise funding for those properties.
Correct.
Certainly, the city's vision was also not just to do residential developments, but also to bring the economy back into the inner city. If you recall, a lot of big businesses left the inner city. So the vision of the city was to say, if we release some of our properties to private sector, it would encourage business and private development to come back into the inner city. So the plans of the early 2011, between 2011 and 2016 came to fruition in 2018, where JPC released about 100 properties for redevelopment into the inner city. The second step was then to say, we are going to expropriate buildings, that's private buildings, and together with our own buildings, create a package that is attractive enough to attract investment into that inner city, be it international investment or domestic investment. But that was the vision which actually came to life in the 2018 period, but had already started in 2000 and between the period of 2011 and 2016. Those plans were already put in place.
Okay. Mr. Kosa?
Thank you. Ake buqhubekile ummeli umnumzana uSidumedi ngokuhloma imibuzo ufakazi. Lapha qhubeke khona ke manje kusendabeni yezokuphepha phecelezi security. Ngoba izolo ufakazi unkosikazi Sidumedi ushilo ukuthi azikho ngaphansi kwamandla abo uma kuziwa kweze security noma ezokuphepha, akukho nje ngaphansi kwamandla abo. Ngakho ke ube esebuza ukuthi uma ezokuphepha zingekho ngaphansi kwamandla enu, ubani ke obese ehlinzeka ngalezi zinsiza zokuphepha kuleli bhilidi? Uchazile ke ufakazi ukuthi kukabili. Okokuqala, uma ibhilidi noma isakhiwo siqashwa, loyo usiqashile kusemahlombe akhe ukuthi ahlinzeke ngezokuphepha nokuqapha lelo bhilidi. Kodwa uma lingazange liqashiswe lelo bhilidi, kodwa kuyibhilidi elingaphansi kwabo, ngenxa yokuthi asikho isabelo mali umkhandlu wedolobha laseGoli obanikeza sona, ubese uthi le mali nizothola ngayo ezokuphepha, kuba semahlombe abo ke ukuthi baceloza kwabo iJMPD ukuthi ihlinzeke ngabantu abazoqapha leso sakhiwo. Nayo iJMPD njengoba nayo idinga abantu ayenele, ngezinye izikhathi yahluleka ukunikeza ukuphepha nokugada leso sakhiwo, kuze kudingeke baphumele ngaphandle ke manje bayofuna ama security noma abaqaphi abazimele. Kodwa ke ukuthola labo bantu kudinga imali. Ngakho izinto lezi ezimbili abaye bazenze ukuze bahlinzeke ngokuphepha. Manje ube sebuza ummeli ukuthi lesi yasakhiwo ke ngoba nasi sikhona ikakhulukazi lesikhuluma ngaso sosindiso, nasuka yini nina nahamba nayo wacela abeJMPD ukuthi sicela nisiqaphele lesisakhiwo ngoba phela lesisakhiwo segameni lethu, futhi ushilo wathi kufanele nithobele imithetho esebenza komasipala nalapho ningaphansi kwakhona. Nahamba yini nayocela bakwaJMPD ukuthi sicela nisigadele, nisiqaphele, nisinikeze security kulesiya sakhiwo sethu sasosindiso ngoba singaphansi kwabo? Uma ephendula umfakazi uthi cha, asiyanga sayolicela usizo. Isizathu salokho ukuthi lesi yasakhiwo sasithathwe ngodli. Ngakho sasingeke sikwazi ukucela amaphoyisa ukuthi ahamba yogada into vele esithathwe ngenkani. Nawo amaphoyisa bengeke avume ukuyoqapha isakhiwo esithathwe ngodli. Ngakho azange sihambe siyowacela ukuthi asinikeze sona. Manje ube semkhumbuza ngale TEA esikhulume ngayo uyokuthi kufanele isebenze, kufanele abantu abangaphansi kwayo bayithobele. Wamusa lapha ya ekhasini ngo86 okuye kwavela ukuthi iJPC yize imelela idolobha kodwa lesi yasakhiwo sasengaphansi kwabo. Ube sebuza ke ummeli ukuthi yini ke nini eniyenzayo ke ukuthi lenhlekelele eyenzeka yomlilo inqandeke, ingabe isaqhubeka nokwenzeka kwamanye amabhilidi akhona. Uthe ukwenaba ke ufakazi uma echaza lapho ngoba uchazile ukuthi kusukela ngonyaka ka2013 ukuya ku2018 kwake kwaba noshintsho. Kwase kuthi izakhiwo ezikhona edolobheni zaba ngaphansi komnyango wezokuthuthukiswa komphakathi, i-economic development. Ngakho phakathi naleyo mnyaka kwakungekho ezandleni zabo. Kodwa kubuyile ngo2018 kwase kuphinde kubuyiselwa ngaphansi kwabo ukuthi kube yibo futhi abaqapha izakhiwo njengoba bekwenzeka ngaphambili. Ngakho ngaleso sikhathi iJPC beyimatasa yenza izinhlelo ukuthi izosebenza kanjani. Empeleni uma ichaza ukuthi kusukela baqala ukwenza izinhlelo baqala cishe ngo2011 belokhu behlela ukuthi yindliphi indlela abazosingatha ngayo manje izakhiwo. Okuqala okunye kwakhe abaqhamuka nakho ukuthi manje njengoba izakhiwo sezibuyele ngaphansi kweJPC njengaqala sezisukile manje ngaphansi komnyango wezokuthuthukiswa komphakathi base bezoqala ukuthi bazithuthukise izakhiwo ezinye bazibhidlize ezingadingeki njengoba base benikezwe izakhiwo kusuka phakathi edolobheni ukuze kuyofika eOrange Grove. Banquma futhi ukuthi ezinye izakhiwo bazozinikeza inkampani ezizimele. Isizathu salokho kwabe kwenzela ukuheha abatshali izimali ukuba bangene edolobheni ngoba abanye base bevele belishile. Ngakho uma bethatha lezi zakhiwo base beqhamuka nohlelo obabelibiza ngokuthi i-Inner City Release Program. Lolu hlelo ulokuthi badedele ezinye izakhiwo kangangokuthi ezinye izakhiwo ezingaba ngo100 bayakwazi ngempela ukuzidedela ukuba zisetshenziswe inkampani ezizimele. Injongo yalokho kodwa ukuthi azilethe imali edolobheni zibuyise umnotho njengoba sezandleni zabo. Banquma futhi ukuthi ezinye ke bazithathe bazibuyisele kubona. Ngakho lezi inhlelo zonke abazenzayo babezenzela ukuvuselela umnotho ngaphakathi edolobheni laseGoli.
Thank you, sir. So we touched on this inner city release program that you are saying has been in place I think since 2018. Can you just explain to the chair? You are saying part of this scheme or this program is to release, for now let's focus on the public owned buildings. We'll come to the privately owned, because this does not only affect public, but it also affects private buildings. You say you must release these properties to the market to attract developers who might refurbish these buildings to revive the economy, as you say. But then the question still becomes, what happens to the occupants of these buildings when you release the buildings to the market?
Yes, Chair. The occupants, one still has to provide them. You can't say to private sector, I'm handing you the building. You've won it via a public tender. Here's the agreement. Now, please fix up the building and take care of the tenants, because you have to provide the tenants with an alternate, or the people that's in the building, not necessarily the tenants. The people that's in the building, you have to provide them with alternative accommodation. You still have to provide them with alternative accommodation, and that's where those temporary emergency accommodations, TEAs, kicks in as well. So that is one of the main obstacles that slows down the whole process of refurbishment, because it is costly. And to ask private sector to pick up that cost, it makes their development not feasible. So there has to be some form of other funding that is allocated for this particular type of initiative, whether it's from another government, another organ of state, for this type of initiative to allow private sector to move in very quickly and reinstate those buildings, because the buildings must be reinstated. They must be refurbished. They must be brought up to standard. These are very old buildings in the inner city. A lot of them have got historical status, but they have to be brought up to standard, whether they're private buildings or whether they're public-owned buildings. That's the reality that we must face, and government can only do that with private sector. But you have to help private sector in that you have to provide those temporary emergency accommodation for the occupants of those buildings. But you also have to profile those occupants of those buildings to see what type of grants they can access, so that when you take them back to the building that has just been refurbished and brought up to standard, you put in, they are able to continue with the rental payments. So providing that alternative accommodation is one of the obstacles, and private sector cannot possibly afford that. I spoke about Venine Court. That is one of, Venine Court was awarded to a private sector. He can get his funding from the various institutions like the social housing, from STRA, wherever they get their funding from. The next thing to do is to empty out the building of the occupants of that building who are illegally there, and then move them to this temporary emergency accommodation so the building can be fixed up.
As a matter of fact, is the program still in implementation? I hear you talking about obstacles, what needs to happen, but is there something happening on the ground to give effect to this release program?
Yes, the program cannot stop. It must continue. We have to find, as a city and as government, we have to find a solution around those obstacles. So from a JPC point of view, in terms of the mandate given to us, that program must still continue. And what we would do is continually seek private sector's help, and then partner with them and assist them where we can, and however we can, not just as JPC, but as a city as a whole, and as government as a whole, one has to assist private sector.
Yes. Because on paragraph 96 or 95, you speak of privately owned properties. Because so far you've been touching on the buildings that are owned by the state or the city. So in paragraph 95, you make reference to privately owned properties that are in a similar state as Usindiso, and you make reference to a report that is attached to your statement. The report appears on page 122. Can you please go to page 122? The annexure bundle. Do you have the report?
Yes, I do.
Can you please look at what is the date of, go to page 128, what is it, when was this report prepared? Or at least signed by the persons appearing on page 128?
29th of June 2022.
So this is prior to the Usindiso incident,
Yes,
right? Go to page 122
yes.
and explain to the Commission what the purpose of this report was under objective paragraph 2.
Okay, the purpose of this report is to provide a plan to the MMC of Economic, is to provide the MMC of Economic Development a plan for privately owned buildings around the inner city. The goal is to acquire, release these properties to private sector for development on a mixed-use emphasis on affordable accommodation for the citizens of Johannesburg.
Right, and under summary there are various issues that you are raising there, but in the second paragraph, and just read the second paragraph, speak about this, the COJ.
The COJ has identified revitalization of the inner city as an essential component for spatial vision for the city, envisaged around a compact city model and a more equitable and efficient urban form. Aspects supporting this focus on the city include parts of the inner city have become dilapidated and unsafe, projecting an undesirable image for the city of Johannesburg, which is contrary to the vision for a city that boasts caring, safe and secure communities. Despite the degradation of Johannesburg, it remains home to a growing number of residents, many of whom are forced to live in inhumane conditions. Addressing this issue is in line with the COJ's commitment to building an inclusive society with enhanced quality of life. access to adequate accommodation that is suitable, relevant, appropriate located, affordable, and financially sustainable, access to affordable student accommodation, access to basic services, water, sanitation, refuge removal, and electricity, security of tenure, irrespective of ownership or rental form and informal structures, access to social services and economic opportunity within reasonable distance.
Right. So,
Let's allow Mr. Khoza to interpret.
Thank you, Chair. Uqhubekile ke ummeli nodaba lwakhe lwalolu yahlelo oluveziwe ukuthi lukhona olubizwa ngokuthi Inner City Release Program, okuhlelo lapha kudedelwa ezinye zezindawo noma izakhiwo ngaphakathi edolobheni. Ushilo manje ukuthi kulolu hlelo kucacisiwe ukuthi lwenzelwa ukubuyisela umnotho edolobheni ukuze idolobha liheha abatshali izimali baphinde bakwazi ukulisebenzisa nomnotho edolobheni uphinde ube njengakuqala ube muhle. Manje umbuzo awubuzile ke ummeli ukuthi uma bededela lamabhilidi bewanikeza inkampani ezizimele kwenzekani kubahlali abasuke behlala ngaphakathi kulawo mabhilidi. Uchazile ke ufakazi ukuthi okokuqala abakwazi ukuvele babakhiphe abantu abahlala khona bese bebashiya dengwane, kodwa kunalokho kufanele kusebenze lo liyahlelo olubizwa ngokuthi TEA lapho kufanele babafunele khona indawo yesikhashana bazohlala kuyo bakhosele, lilungiswe ibhilidi, uma beqeda libuyelwe kubona. Kodwa manje iyona ke ingqinamba ababhekene nayo nebanqindayo ukuthi baye phambili indaba yokuthola isakhiwo esinye abangahlaliswa kusona ngesikhathi kusalungiswa leli bhilidi. Uthi leyo nto iyinkinga enkulu eyenza ukuthi lolu hlelo olubizwa ngokuthi Inner City Release Program lushaye ngolonwabo lungasheshi ngenxa yokuthi kunzima, kanti futhi kuyabiza ukuthi baphinde bathole izindawo zokubahlalisa laba bantu, ngoba uyavuma ukuthi amabhilidi amaningi alapha edolobheni laseGoli akudinga ukuvuselelwa. Amanye asemadala kakhulu, amanye anomlando mude, awukwazi ukuvele nje uhlalisa abantu kuwona, kudingeka bawalungise. Manje ukuze baphumelele badinga ukubambisana nezinkampani ezizimele, kodwa nakuzo okunzima kakhulu ukuthi bakwazi ukuwalungisa. Kodwa ke bayazama ukuthi njengamanje baqhubeke nalolu hlelo ngisho kungelula ukuthi luye phambili. Uthe uma ibuza lapho ummeli ukuthi lolu hlelo liyasebenza yini ngempela njengoba sikhuluma, wathi ngeke baliyeke, bazimisela ukuqhubeka nalo ngisho lushaya ngolonwabo kodwa bazimisele ukwenza. Wenze isibonelo ngesinye isakhiwo esibizwa ukuthi Vanning Court, nakhona futhi sinikezwe ezinkampani ezizimele. Kulesi sakhiwo kunabantu abangene ngodli abahlala ngokungemthetho. Manje abakwazi ke ukuthi bavele babakhiphe nalabo bantu. Kufanele baqale bababheke kuqala ukuthi uma ngathiwa bayabakhipha bazokwenza lokho kuthiwa ukuba profile, ukubabheka ukuthi uma bebuyiselwa ngesinye isikhathi kuleso sakhiwo bazokwazi yini ukusinakekela. Manje balidinga kakhulu usizo, hayi nje kuphela lwekhandlo edolobha laseGoli kodwa nokubambisana nenkampani ezizimele nohulumeni ukuze bakwazi ukukulungisa lezi zakhiwo futhi benze ukuthi lolu hlelo lwabo olwe Inner City Program lusebenze ngempumelelo. Ummeli ke ubesedlulela ekhasini 95 lapho ecele khona ukuthi ake kuthi ukuxoxwa kancane ngalamabhilidi sezandleni noma aphethwe inkampani ezizimele noma izinkampani zangasese ama-private owned. Lapha ekhasini 95 kunombiko owabhalwa. Lo mbiko utholakala ekhasini 122. Ummeli umcelile ukuthi akakawubheke lo mbiko bese esho ukuthi owanini. Isignature noma ukusayinwa kwawo kwenzeka ngomhla ka-29 June 2022 kwangaphambi kokuthi kuqubuke umlilo. Ubesethi akakathi ukuchaza ngalo mbiko abawubhalile ukuthi wawenzelwani, inhloso yawo yayiyini. Uma ubheka isethulo sawo siyachaza ukuthi inhloso yangempela yalo mbiko kwakuwukuthi kubhalelwe uMMC wezokuthuthukiswa komphakathi bamchazele ukubaluleka kokudedela ezinye izakhiwo ziye ezandleni zezinkampani ezizimele. Yachaza ukuthi inhloso yalokho ukuthi umkhandlu waseGoli iCOJ izmisele ukusebenzela ukuvuselela amabhilidi akhona. Isizathu salokho ukuthi ezinye izindawo zalamabhilidi aziphephile. Abantu bayahlupheka abahlala kuwona. Ngakho bona into ewumgogodla kubo njenge-COG ukuyisebenzela ukuvuselela lezi zakhiwo. Bazame ukuthuthukisa zibe sesimweni esihle. Futhi bazame nokuthuthukisa izakhamuzi. Kulombiko kuvela ukuthi enye yezinto abafuna ukuyenza ukuthi izakhamuzi zihlale ngokulingana. Kungabikho ukucwasana kuzona. Izakhamuzi zibe namanzi, zibe nogesi, zibe nesimiso sokukhuculula indle, ziqoqelwe udodi, ziphinde futhi zikwazi nokuthola izinsiza zikahulumeni. Konke lokhu kuyinqala sizinda nenhloso omgomo abazimisele ngayo bona njenge-COJ. Ngakho yilokho ke kwenze babhala lo mbiko obecele ummeli ukuthi awubheke osekhasini 122 ngokuphathelene nezakhiwo ezisezandleni zezinkampani ezizimele.
Thank you, sir. Now, in page 123 of that same report, under paragraph 3.1, you see that? We have said we have investigated advantages and disadvantages of the following options that are available to the city to implement this release model. Can you just highlight to the commission what were the options? You don't have to read the nature of the option, but you can just speak to 3.1.1, the 3.12, and 3.13 without necessarily reading the document.
So yes, the one option is to enter into abandonment agreements. Some buildings have been abandoned. We can't find the owners. And those buildings are in a poor state. They've been hijacked. There's a lot of criminality in that. So we asked for permission we go to council and ask for permission to acquire these buildings by an abandonment agreement, which we would sign. Those properties are not in the name of the city, the ones that we are
Correct.
talking about. An example of this one I can give you is remember the Florence Nightingale building in Hillbrow? It's a building that we have to acquire as a city in some form, because that building in its current state the owner is long gone. We can't find the owner. And the only way to get it is by doing an abandonment agreement in a legal manner. Some owners we can find they've probably left the country and left their buildings in the state, in which case we'd sign with them and ask them, can we take over the building? And then the second option is to purchase the building where we can find the owner. And how do we purchase that building is most of those buildings would owe the city arrear rates and taxes. And then we would start negotiating with the owner to say, okay, you're not paying your rates and taxes. You have also left your building in the state. We value the building and purchase at whatever that price is. If we owe them any money, some of the arrear rates and taxes, they then actually owe the city even after we've valued the building. And then the last method is the expropriation method, where we expropriate the building if A, we can't find the owner, or B, as he doesn't want to sell, but the building is in a poor and it's not habitable state. And then a declaratory order, where the option is to obtain a declaratory order, where we can't find the owner as well. We cannot trace the owner.
Correct.
Sorry, I gave the wrong example. Florence Nightingale building is such a case.
This is a case where you can't
You can't trace
the owner.
the owner.
Correct.
And then the rear rates and taxes. So there are a number of buildings in the inner city where the owner can't be found, and we'll have to use those various options. You can't trace the owner. And then the expropriation route is, if we can find the owner, becomes willing buyer, willing seller at the price valued by an independent valuer. If we find each other on willing buyer, willing seller basis, if not, then we'll use the appropriate mechanism to expropriate the building, but still pay that compensation as per that value.
Correct. Mr. Kosa?
Thank you, Chair. Njengamanje ummeli ubesembhekisa ufakazi ekhasini 123 usaqhubeka nawo umbiko abawubhala nezihlongozo ke abazibhala kulombiko. Yebo kukhona ubuhle bazo nalapho futhi okungekuhle kukho lombiko akuchazile. Babeka ke manje ukuthi kunezinto abangasebenzela kuzona ezingabhekwa njengama options ukuthi ukuze basebenze ngalezi zakhiwo kufanele basebenze kanjani. Kunezinto ezintathu okungakhethwa kuzona abazibhale kulombiko becela ku MMC ukuthi nazi izinto ezintathu esicabanga ukuthi zingasebenza uma kuziwa kulezi zakhiwo. Eyokuqala ukuthi kwenziwe isivumelwano ngalezi zakhiwo noma amabhilidi aseshiwe dengwane ukuthi sikhona yini isivumelwano esingabhalwa phansi. Okokuqala lamabhilidi njengoba engasana kwemuntu ubugebengu budlangile kuwona. Amanye awo asethathwe ngodli. Manje amanye amabhilidi awaziwa nokuthi akabani. Igama lakhona alisatholakala ukuthi ubani umnikazi wawo. Manje indlela yokuqala ke lena iCOJ engayenza noma umkhandlu wedolobha laseGoli ukuthi lawo mabhilidi akwenziwe isivumelwano ukuthi uma kutholakala amabhilidi anjalo lakwazi ukuthathwa abuyiselwe egameni lomkhandlu wedolobha. Bese okwesibili ioption yesibili okungakhethwa kuyona ukuthi amabhilidi uma etholakala athengwe. Kodwa manje azothengwa kanjani? Amaningi alamabhilidi aseGoli amanye awo angathengwa ayakweleta kakade njengoba ehleli lapha ayakweletwa. Ngakho kungakhulunywa nomnikazi wawo ukuthi akweleta intela enkulu ama rates okufanele ngabaya wakhokha awakhokhi. Kanti ke futhi usulishiye dengwane leli bhilidi. Kanti okwesithathu awulinakekeli alikho esimweni semithetho ebekwe umasipala ukuthi libe kulona. Ngakho sicela ukulithenga leli bhilidi. Indlela yesibili leyo. Indlela yesithathu ukuwathatha. Anjani ke athi uyathathwa ufakazi uchazile ukuthi athathwayo amaningi yilapho bezama ukulandelela bafuna ukuthi ubani umnikazi waleli bhilidi bangamtholi. Wenze isibonelo ukuthi elinye lamabhilidi libizwa ngokuthi iFlorence Nightingale lingena ngaphansi kwaleli bhilidi. Lapho befunile umnikazi walo bangathola ukuthi ubani kahle hle umnikazi waleli bhilidi. Ngakho amabhilidi anjalo ayafunwa athathwe ke kanjalo. Kodwa ke uma futhi ekhona umnikazi walevela bazimisele ukuthi balithenge kuxoxiswane ukuthi siyalithatha leli bhilidi siyalithenga. Kwenziwe isivumelwano esibizwa ngokuthi willing buyer willing seller bavumelane bese belithatha lelo bhilidi. Kodwa konke lokho kufanele kwenziwe kulandelwa imithetho. Ngisho belithathile ke bazimisele ukumkhokhela isinxephezelo salelo bhilidi ngemva kokuthi kube nezingxoxiswano ezikhona phakathi kwabo. Ngakho lezi izindlela ezintathu abazihlongozayo kulombiko wabo izokubuyisa amabhilidi abe ngaphansi kwegama lomkhandlu waseGoli futhi akwazi ukunakekeleka kahle.
Thank you, sir. And then you continued on page 125 to speak about the block-by-block approach. Can you just explain that to the Commission, what that entails?
So when we came up with this approach, block-by-block approach, it was a vision to say, how do we revitalize the city in a manner that's going to create a meaningful impact? Because the city has evolved over the years, and all big cities have to change. Johannesburg is a big city, which has unfortunately gone into a dilapidated state. So this block-by-block approach was really to revive the city and focus on a block and make it very economically attractive and commercially attractive to private sector to partner with us. So instead of fixing up a building on one side and then moving down 20 streets and building up a building on the east side or the west side of the inner city, we then decided, let's look at a block and a building in a block and actually fix up a full block and then move on as we come across more buildings in a block that needed, whether it was private sector or whether it was a government building, not necessarily just only the COJ buildings, but any form of government, was to then say to them, okay, let's partner together with private sector and all stakes of government and start fixing up the city block by block. So we wouldn't just fix up a building in the block. If there was informal trading in the block, we would work on that as well to fix up that particular area. If there was a taxi facility or in that block or shops in that block, and within those blocks also create some commercial activity to support the residential activity. So that was the approach, to actually do a big bang approach using these buildings in the inner city.
Correct. Now, we want to go through what is contained in paragraph 5. But when I look at paragraph 5, that appears on page 126. You indicate there that in the case where the city does not have the budget to compensate the acquisition of these properties that have been identified, a new model is proposed, right? And you list A to E, the interventions that will be put in place to mitigate against this not having sufficient funds. Have these been implemented?
No, not yet. We are still in the process of implementing, but it's not been implemented as yet. And I think when it comes to, if I can just add to that, when it comes to working out financial models for these buildings in the absence of the cities, in the absence of funding, as the economy changes, one has to relook at your various financial models that you want, but it's not been implemented. We had started in 2022 on the first release that we did, and we had identified a substantial number of both private and city properties that we needed to go with the next phase.
So how many properties were released in the first phase?
100 properties.
100 properties were released by the city
By JP, yes.
for the purposes of redevelopment.
Yes.
And this was following the same model as envisaged in this memorandum.
In this memorandum, we took a block by block approach. That was our first release. And we released single properties and consolidated some of them into some developments. So that would equate into about, I think, 24, if I stand to be corrected, developments. This particular one, and we were really testing the market to see if there would have been take-up from private sector, and there was. There was an interest in private sector, from private sector, and probably still is. This particular release was a much more aggressive approach to move a lot faster than what we had moved previously. So our vision as JPC was release a block and the winner takes it all by a public tender. So instead of somebody getting one building, if the block contained 4 buildings, then he would respond for those 4 buildings. It's made it economically and much more it would have attracted a lot more investors into the city. So that was this particular one. It was a lot more aggressive compared to the first one.
Okay. And then you continue on your statement about a report that is paragraph 99 of your statement. Sometime in September 2023, obviously this is a date that comes after the tragedy at Usindiso. You informed the commission about the report that speaks to some of the plans that you have for what you call bad buildings. Maybe you can just explain what are bad buildings.
Okay, my definition of bad buildings would be a building that one is not habitable. In other words, I cannot get a electrical compliance certificate or a fire certificate of the building. It's structurally unsound, the sewer's not working, the building's overcrowded. So that would be defined as a bad building. It's also, I would identify under the bad building because it's also a hijacked building. Hey. And you'd normally find a lot of overcrowding in those buildings, so yes.
Okay.
So it's just not habitable. It doesn't meet any of the requirements of habitability.
Okay. And then you attach a report contained, you leave HB 13, that appears on page 129 until 152, but we won't go through the entire report. They're just key aspects of the report that I would like you to explain to the Commission. First, we go to the background on page 130 of that report. But first, let's first go to page 129 under objective, what the purpose of this report was.
The purpose of this report is to provide information to the sub-mayoral committee on the list of bad buildings owned by the city in Region F.
Right. And then under background, the first paragraph, what are you telling the sub-mayoral committee? Page 130.
Based on the need for affordable housing within the city and its surrounding areas, the following city-owned properties have been identified as bad buildings within the city. The vision for these properties is to ensure that they are restored to a habitable state, either by sale or redevelopment, and ultimately assist in resolving some of the existing issues surrounding the city. The following table is an overview of properties identified and is categorized in Part A and Part 2.
All right. Now, let's just look at key points arising out of those different parts. We are not going to go through each and every table, but under Part 1, just explain to the Commission what are those buildings.
Part 1, these buildings are buildings and properties in the inner city that we released to private sector. Remember I spoke about our inner city release program in 2018.
Yes.
This was the properties that we released to them. And we say they're active leases because we entered into development leases and the lease period was for 25 years. And the developers had to then develop this into affordable housing accommodation.
Yes. And if
So that's the purpose of Part 1.
in actual fact, when you go to page 132,
Yes.
it provides a list of the buildings that are a subject of Part 1.
Yes.
Am I correct?
So remember I spoke about Venine Courts
Yes.
previously. That's one of the buildings that we released to private sector.
Correct.
And then Beaconsfield, which is I think also on one of the court orders, as a second building
Yes.
that we've released to private sector for accommodation.
All right. And then we go to Part 2. What are Part 2 buildings?
So Part 2, these are what we call social properties, social leases in the inner city. They're still current. You see lease type as social.
Yes.
So they're used for social purposes.
Maybe let's
Now-
use an example of that. If you go to page 135,
135.
135 is I want us to look at examples of the
And,
Part 2 buildings.
and then you've got, as an example, I'm just going to give you, it says commercial, F5558 Newtown, 591 Newtown. This is the Newtown Mall that we've, it's probably this building as well, where we've actually entered into a lease with a lessee for the running of this building, and the Newtown development next door. And then you've got the Rissik Street Post Office, where we've, I think a few years ago, the Rissik Street Post Office burnt. And in the process of trying to redevelop this building in line with the heritage status, because some buildings, which is another hurdle that one has to cross, some buildings do have the status of a heritage building, which makes them very expensive to renovate. So the Rissik Street Post Office, as an example, was put out on tender a number of times, and in the process of rebuilding it and fixing it up during COVID, this building was invaded actually, and we could not evict the tenants. We managed to curb the invasion, but the tenants that were there, we could not evict them, and that's not a residential building. And one of the reasons that we could not evict them was one of the NGOs stepped in and stopped the evictions and took us to court for that eviction. But this is not a residential building that was invaded.
What is the status of that?
It's still
Building now?
invaded, but we've managed to control that, and we've now trying to get it funding to rebuild it in line with the heritage standards.
Okay. I want us to go to Part 5, because Part 5 speaks to the buildings. If you go to your statement on page 88, you are saying in Part 5, there are 17 properties that are in Part 5, right? Which have been identified for sale or alienation. And Usindiso building is part of one of these Part 5 buildings where you are saying this earmarked for sale or alienation. And the JP is, however, in the process of applying for a demolition certificate to demolish Usindiso, as the integrity of the structure has been compromised. Can you just elaborate for the benefit of the Commission the JPC's stance and approach towards Usindiso in its current state?
So after the building burnt, it was secured, and it was actually so that, and then all the structural integrity studies were done on the building, and the building is not structurally sound after the fire. So it not being structurally sound, we now have to demolish the building. As JPC, on behalf of the City of Johannesburg, we have to demolish the building. And we've actually applied for a demolition certificate. We have to apply for the demolition certificate. We have to follow the rules. We've applied to our planning department for the demolition certificate to demolish the building. I think there was a court order that came out in December giving us permission that the building is not structurally sound and it must be demolished. That we should get the certificate in about 2 or 3 weeks' time. In the meantime, what we have started to do as JPC, we appointed a contractor to fence off the building, and we have had our own teams, repairs and maintenance team, removing certain structures from the building so that it's not reinvaded, because it can be reinvaded. So that's what we've done, and JMPD using their own personnel, they do assist us in, but it does take a lot of manpower. So the building is currently being closely watched by the JPC team.
Okay.
And they're removing salvageable materials from the site. But it's also a form of security by keeping our staff on the site.
Okay. Mr. Kosa?
Thank you, Chair. Uqhubekile ke futhi ummeli ohola ubufakazi ngocela ukuba ufakazi aye ekhasini 125 lapho acele khona ukuthi akakathi ukuchaza ngalolu hlelo olubhalwe phansi ngokuthi i-block by block ukuthi lisho ukuthini. Lena ufakazi uthi indlela yabo abaqhamuke nayo abathi bazoyisebenzisa ekuzamani ukulungisa lamabhilidi lendlela ye-block by ball block. Okokuqala yenzelwe ukuthi ivuselele amabhilidi iphinde ihehe abatshali izimali ukuthi babuye bazosebenza ikakhulukazi abazimele. Kodwa njengoba ichaza ithi block by block indlela abasebenza ngayo bathi banqume ukuthi kunokuthi bathathe uhlangothi olulodwa lebhilidi balungise bese beqela kwalunye kwelinye ibhilidi futhi bathathe olunye uhlangothi kunalokho banqume ukuthi bazosebenza ngebhilidi lonke ngakho onke amabhilidi alapho abhekwa njengeblock bazowalungisa bese bedlulela kweyalandelayo iblock nayo futhi iphinde ilungiswe. Lena bayibona njengendlela ezokwazi ke manje ukuthi bakwazi ukuhamba kahle ngendlela ehlelekile balungise amabhilidi ngamabhilidi kunokuthi balungise uhlangothi olulodwa lebhilidi bese bedlulela kolulandelayo. Udlulile ke lapho wayese eqhubekela phambili endabeni yesabelo mali ekhasini 25 ekhasini 126 uxolo isigaba ngo5 lapho ebuze khona ukuthi ummeli uma isabelo mali singenele kulomsebenzi njengoba umkhandlu edolobha ungenayo imali eyanele yokwenza lokhu yipi indlela eninqume ukuyisebenzisa. Kulombiko wabo kuvela ukuthi kunohlelo olusha olubizwa ngokuthi i-new model abafuna ukuthi balilingise njengoba bezama ukusebenza kulolu hlelo. Kodwa manje ubuzile ukuthi seniqalile yini ukulisebenzisa. Uthe cha abakaqali ukulusebenzisa lolu hlelo lezimali ngoba yilona oluzobasiza ukuthi bakwazi ukufinyelela umgomo wabo wokwenza i-block by block ekulungiseni. Ubesebuza futhi ummeli ukuthi mangaka amabhilidi eseniwadedele ngokwalolu hlelo lwabo njengoba beseke asho ngaphambili uthe angu-100 abase bewadedele inkampani ezingaphandle nabatshali izimali ukuthi baqale ukwalungisa. Bakubheka njengento negxathu elingabasiza ekutheni basheshe kulokhu abakwenzayo ngoba kuheha kakhulu abantu uma umuntu azi ukuthi uma ezothenga uzothatha cishe yonke leyo ngxenye yamabhilidi akuleyo ndawo. Ngakho kunokuthi badedele ibhilidi elilodwa bangadedela mhlawumbe amabili amathathu ngesikhathi esisodwa benzela ukuthi kusheshe kulabo abanesifiso sokuwathatha bese bewalungisa ke aphinda abuyele esimweni sabo. Kube sekudlulelwe kwistatimende sekuyisigaba 29 lapho ekhulume khona ummeli embuza ngencazelo yakhe ukuthi kulesi statement noma kulombiko wakhuluma ngalokho okuthiwa ama-bad buildings noma izakhiwo ezimbi. Usho ukuthini ufakazi uma bechaza ngalokho? Incazelo yakhe ke ya lama-bad buildings ithe isho amabhilidi agcwele ngokweqile, amabhilidi angithathwe ngenkani, amabhilidi angakwazi ngisho ukwanikeza isitifiketi sokuthi ugesi usebenza kahle. Izinto nje lapho zibheda khona wonke lawo mabhilidi awachaza ngokwencazelo yakhe ukuthi uwafaka ngaphansi kwesigaba esisodwa ngokuthi ama-bad buildings noma izakhiwo ezimbi. Ubesemcela ukuthi akakabheke amakhasi 129 kuya ku152 kodwa ayingenhloso ukuthi afunde konke okubhalwe lapha ya. Kodwa manasha amazwibela nje ukuthi iziphi ezinye zezinto ababezihlosile ngesikhathi bebhala lombiko. Kodwa ucele ukuthi ake kuchazwe kuqala inhloso yawo lombiko. Uyayibhalelwe bani? Uma ifundwa lenhloso kuthiwa yayibhalelwe i-Sub-Mayoral Committee. Ikomiti lena ekhona yomkhandlu iyona yayibhalelwe lombiko. Yayibhalelwe ini? Kulombiko uyachaza ukuthi idolobha laseGoli lalifisa ukuthi edolobheni kufanele kube nezindawo ezingatholakala kuhlale kuzo abantu. Lo mbiko kodwa ushilo ukuthi ubhalwe ngoSeptember 2023. Kusobala ukuthi bese yenzekile lenhlekelele ngesikhathi beqala bebhala lo mbiko. Kodwa lo mbiko wawuzo nikeza ihlongozo zokuthi edolobheni makutholakala izindawo ezizohlalisa abantu, zibahlalise kahle, izindawo futhi ezikwazi ukukhokheleka, abantu bakwazi ukukhokha kuzona, zingambi eqolo kakhulu. Ushilo futhi ukuthi kusukela ngaleso sikhathi njengoba beqale ngo2018 besebenzisa lolu hlelo, zikhona njengoba sikhuluma izakhiwo ebese zivele zithengiwe, bese zivele zisezandleni zeinkampani ezizimele, kodwa kubonakalayo ukuthi nazo ziyawohloka, azinakekelwa. Ubale izakhiwo lezi akakhuluma ngazo ngaphambili, iVenin Court, wabala neBrixfield, nazo manje zonke lezo ezisezandleni zezinkampani ezizimele, kodwa kubonakalayo ukuthi zidinga ukulungiswa zibe sesimweni esikahle. Ube ummeli esedlulela njengoba ekhamazwibela kulombiko wakhe waya kuloko kuthiwa iPart 2 yalombiko wabo. Kule Part 2 ilapho kukhulunywa khona ngokuqashisa abantu abahlala khona ngokupheceleza social leases. So kuyona kuhlanganisa ke nalabo abazokwazi ukwenza inzuzo. Ngokwesibonelo ubhekisele kuNewtown ukuthi nayo iseyinhlelweni ezingaphansi kwalolu hlelo olusengcenyeni 2 lapho kulungiswa khona. Ngokwesibonelo kuneposi ku Risick Street elasha eminyakeni edlule. Lelo posi nalo lidinga ukulungiswa, leyo post office. So ingena ngaphansi kwalesi sigaba embikweni wabo esiku Part 2. Bese kuba khona izakhiwo ezinomlando nawamagugu. Kunzima ukuzilungisa lezo ngoba kuyabiza. Ezinye zalezo zakhiwo ezinomlando emlandweni okungakhulunywa ngazo sezithathwe ngenkani, sokukhona abantu abangene kuzo ngenkani. Ubale nje esisodwa sazo lapho kwaze kwaqhamuka khona inkampani noma inhlangano engenza inzuzo eyabathatha yabafake inkantolo njenge JPC. Ngakho kwenza ukuthi labo bantu abahlala lapho bangakwazi ke ukubakhipha. Kodwa yize bengakwazanga ukubakhipha, kodwa leyo ndawo njengamanje yalawuleka. Basahlala labo bantu lapho ngoba uma ubakhipha kufanele na kanjani ubatholele enye indawo yokuhlala. Ubese dlulela ke engcenyeni 5 ngaphansi kwePart 5 lapho kunezakhiwo ezingu17. Ilapho ke kuPart 5 lapho nosindiso building lungena khona. Uthe kulombiko wabo bese besifakile isicelo sokuthi le liability lasosindiso ngemva kwenhlekelele bafake isicelo sokuthi alibhidliswe lingabe lisaba khona. Kodwa yini abayenzayo njengamanje? Ushilo ufakazi ukuthi njengamanje le liability baqhashe abantu abaliqaphile ukuthi baligade ngoba namanje le liability kulula nje ukuthi abantu basengaphinde balithathe futhi ngodli bangene ngenkani babuyele kulona. Ngakho balibiyele njengoba sikhuluma basebenzisa amaphoyisa nethimba leJMPD ukuthi libasize baliqaphe ukuthi kungenzeki lokho kwenzekile ukuthi kuphinde futhi leli liability lithathwe ngodli. Basifakile isicelo emavikini amabili noma amathathu alizayo balindele impendulo ezobe sibanikeza igunya lokuthi sebengasithatha isinyathelo sokulibhidliza leli liability. Kodwa okwamanje baqoke inkontileka ezimele ukuthi iligade ilibiyele isize kanye nethimba leJMPD nalo libekiso kuleli liability ukuthi kungaphinde kwenzeke. Ngakho indlela manje abasaligcine ngalo kodwa besalinde impendulo yesicelo abasifakile. Ngakho leli liability lingena kule mbiko wabo ngaphansi kwengcenye enguPart 5.
Thanks. Chair, if you can just indulge me, I know it's just about lunchtime, but I'm literally having only one point to
Yes.
canvass with the witness, and then we can just stretch lunch a little bit, and then we'll
Yeah.
be done with this witness.
Yes, I
Thank you.
think that will be appropriate.
Thank you, Chair. But before I do that, Chair, because there are documents that this morning I had asked, wanted to give to the evidence leaders, because they speak to this interdicts the demolition certificates that the witness has been speaking about. I know they were put in the bundles, but I never got a chance to canvass them with Advocate Seminya. I'm not sure whether is he going to take issue with me introducing the documents. Thank you very much. Now, you spoke earlier on about,
Is he saying he's not taking issue with that?
he's shaking.
I don't take issue, Judge.
Thank you.
My apologies, I just saw him shaking his head. Ms. Botes, you spoke and you made an example about Usindiso, that as an example, Usindiso, we are waiting for a demolition certificate. So that's Usindiso. But I think in your testimony, you did allude to the fact that there are other buildings in the city that are of a similar status. So I just want you to take the commission into the interventions that the city, other than the inner city program, you spoke about the property release program, to speak about other mechanisms that the city has employed to ensure that these so-called bad buildings or hijacked buildings, we are able to get the occupants out of those buildings. There are some court orders on your bundle of annexures from page 177 to page 210. I won't go through all of them, just want to use two of them as an example. Are you there? Then you just go to page 192 of that document. It starts on page 190, but I've got, my interest is more on page 193. You see page 193?
Yes.
Is dated, is an order dated the 14th of November 2023. If you just go to explain to the commission the measures that you have put in place now to, in an attempt to find a solution to the evacuation of these buildings.
Yes, thanks, Chair. So I speak now on behalf of the City of Johannesburg. But because this is a court order that would have been applied for by the city's legal department under the management of the city manager. But to say they have consulted JPC before they went to court, so I'm aware of their interventions. But still to say that I do speak now on their behalf, that where a building is declared unsafe for human habitation, that we've identified, though that's the intervention, and we identify that building by, I think I've given an example, if you can't get
The owner?
no, if you can't get the, sorry, I just lost my train of thought.
Okay. Let's talk about, so
If you can't get the occupancy certificate because the building is not, you can't get an electrical compliance certificate, if you can't get a fire safety certificate, that building then is not habitable.
correct.
Secondly, if the building is structurally unsound, and the way you determine if a building is structurally unsound is that you have to get a structural engineer's report that declares the building structurally unsound. But the two certificates before that, the EMS certificate, that's the fire certificate, and the certificate of electrical compliance, if those two certificates are not in place, and a water and sanitation certificate, if those certificates are not in place, your building is not habitable and it must be evacuated.
Correct. Yes.
In
Now-
this case,
What I'm keen on this specific one, if you go to page 194,
yes,
the second order, what does that order read? Paragraph 2?
the property situated at Wimbledon Court Building, F2253, number 77 Balmoral Street, Johannesburg, and in brackets, the property is declared unsafe for human habitation.
Right. Now, there's a declaration of this building being unsafe for human inhabitation.
Inhabitation, yeah.
Now, go to paragraph 3.2, 3.3, and 3.4. What are those orders saying?
The city is directed to engage meaningfully with the representative of the occupiers of Wimbledon Court Building for the purpose of evacuating the first respondents from Wimbledon Court Building. 3.3, the city is directed to conduct an occupancy audit of the persons residing at Wimbledon Court Building. And 3.4, the city and the respondents are directed to engage meaningfully in respect of the temporary emergency accommodation for the purposes of evacuation of Wimbledon Court Building.
Now, with this type of an order, we know it was granted, at least on the face of it. Actually, the stamp is there on page 195. It was granted on the 14th of November 2023. I just want you to take the commission to the, in as much as the order was granted on the 14th of November, would you be able to evacuate, and two issues, the building is declared unsafe for an order. On the 14th of November, would you be able to evacuate this building in accordance with, if you look at paragraphs 3.2 and 3.4?
Would I be able to evacuate?
What are the processes that the city must still undertake to ensure that this order is given effect to?
Yeah, it's a it's a difficult order. The difficulty arises in it's possible, but difficult in terms from a time frame of view. The building's unsafe. If somebody says the building's unsafe, you must evacuate immediately. I'll give you an example. We did it in September, where we evacuated the Metro Centre because the Metro Centre is declared unsafe. But I had to go and find, and it's easy for officers to find surrounding offices for about maybe 1,000 people. 2,000 people don't have offices. But in the case, and that's officers. But once a building, as I've mentioned, is unsafe, people must leave the building immediately. Now, if you're going to engage meaningfully, that engagement can take a long time to engage with communities. It's not an overnight thing. Our experience shows that the demands that communities would put on the table for accommodation is not going to take 2 weeks or 2 months. The second thing, and communities want to have a say as to where you put them. They're used to living within this particular area. They're going to want to go and live in that area close by with what they're familiar with. The city's got no properties in the inner city of habitable state or vacant that they could move the residents of this particular building to. The second thing, to do an occupancy audit shouldn't take long. But 3.4, temporary emergency accommodation. Okay. My analysis, based on the asset register of the city, is to provide emergency accommodation. The city cannot provide emergency accommodation within the inner city region. It's going to take a number of months. You can provide emergency accommodation, but it's going to be out of what we call Region F. I, as the property custodian, would have to go and look for what I would call vacant land. And the vacant land currently is on the outskirts of the city, not on transport nodes. My assumption is that these residents are going to want property along a transport route. Now, emergency accommodation, to provide emergency accommodation, presuming I'm giving the city vacant land, we're going to have to make sure that emergency accommodation has got water and sanitation. So we're going to have the relevant infrastructure in place. For that emergency, wherever they put this emergency accommodation, there's going to have to be the necessary infrastructure to support that. So it is a hurdle that the city is going to have to overcome to implement this court order. I'm not saying it's not implementable, it is implementable, it's just not implementable within a few days. Because the minute you declare something not safe, you must act on that with immediate effect and move everybody out. But putting in this particular clause, please provide TEAs. We're going to have to make those sites available, and those sites are not available within, as I've mentioned, within this Wolmerans area.
Before I let Mr. Kosa do the interpretation, just to give context to what you're talking about, can you please go to page 199? That order actually starts on page 197. It is a different building.
I must go to page 197.
197. Just to confirm that it is a different building from the one that we were just reading, the Wimbledon one. So 197 is a property known as Casamia. Can you see that? Similar order on paragraph 3, 4, but just go to paragraph 5.4. That appears on page 199. Just read that paragraph 5.4 on what is it that you must engage the occupants on. Just read out paragraph 5.4 for the record.
The city shall engage the first respondents on the following issues to ensure that the evacuation is implemented expeditiously with due regard to the circumstances of the first respondent, the timing and method of evacuation, the specific personal circumstances of each of the first respondents, the anticipated duration of the first respondent's relocation, and the nature and the content of the comprehensive structural investigation to be carried out on the property.
So this paragraph amplifies what you have just been telling the chairperson as to what are the things that you face on the ground unit, or what are the issues that you must engage the unlawful occupiers about.
Yeah, I'll say again, I'm not the city. This is almost an impossible court order. First of all, Chief, with due respect, this is unlawful occupiers. I've mentioned earlier on that sometimes people invade buildings to get ahead of the housing list, to get ahead of what COJ Human Settlements is currently working on. This is one way. Now, the court order says you must give the unlawful occupiers legal tenants. You must make them legal tenants. You must engage with them, and then you must come up with the time and method of evacuation.
Now,
And I suppose, if I understand it correctly, you must also engage with them as to where they must be placed, where they want to stay, where their next home is. Most people are going to choose, in terms of these court orders, they're going to say, I want to remain in the inner city. The city spatial plan, the city spatial plan, living outside the inner city is very expensive. And that's spatial planning of the apartheid years, and that's what the city over the years has tried to fix up. But it's almost, you tie the city's hands. You literally tie the city's hands with these court orders. because you don't allow the city breathing space to fix up the buildings. It's an easier court order if you say to the city, identify a property on the outskirts for this particular period. And we, as a court, give you so much time to fix up your inner city. And then bring the people back. The city spatial development framework was designed to say, let's make this a compact city, let's make this an economically viable city. But you're refueling this bus as it is moving, and you tie the person that must fix up the city, you tie in their hands with such court orders. It's a good court order because it gives us, it's a court, not a good court order, it gives us it gives us some breathing space, but it still chokes the city because you're saying, engage. I must engage, it's correct. But I don't have space within the inner city to move people around until I fix it up. And those buildings must be fixed up. That's an acknowledgement that the city makes. That's an acknowledgement that I, as the CEO of JPC, makes, that those city buildings must be fixed up. But the people have to be moved out to a space designed or designated by the city and then brought back once those buildings are fixed up. We're not saying as a city that once we put you somewhere you can't come back to the inner city. The city spatial development framework says you must come back to the city. It's a polycentric city. You must come back to the city. We must make it an economically viable city, and that is why the city designed the TODs, the transport-orientated developments, so that we can provide housing along the transport routes to make it cheaper for the people. But we need space and breathing space to work. Tying our hands and saying, fix up the inner city while the people are there. The inner city, the inner city must be a construction site because there's so much development and reconstruction that must happen. And you can't have people in a construction site.
Okay. Mr. Kosa?
Thank you so much, Chair. Ayike buqhubekile ubufakazi nje ngoba uhola ubufakazi ummeli eqale wakhulumisana nabanye bameli advocate Simenya ngokuthi angakwazi ukuqhubeka nama document athile abakufanele baqhubeke ngawo ngemva kokuvumelana babe sebeqhubeka ke ngalawo ma document uma engena eqhubeka nendaba yamabhilidi lana achazwe njengokuthi amabhilidi amabi ummeli ube semcela ukuthi ake khanjwe kubheke imiyalelo yenkantolo ukuthi ithini ngala mabhilidi amabi nokuthi iziphi inhlelo njengamanje asebezenzile bona njengedolobha noma iJPC okuyiyona emelele idolobha kulandeleni leyo miyalelo yenkantolo. Umyalelo wokuqala wenkantolo utholakale lapha ekhasini 177 kuya ku 210. Lo myalelo wenkantolo wakhishwa ngomhla ka 14 November 2023. Lo myalelo wenkantolo ukhuluma ngokukhishwa kwabantu okufanele kwenzeke mabhilidini abhekwa njengamabhilidi angekho esimweni esihle. Ngakho uthe ummeli ucela ukuba ufakazi akhulume ngalawo mabhilidi. Ufakazi ushilo ukuthi uma manje sekhuluma ngaleyo myalelo wenkantolo uzobe sekhulumela iCOJ noma umkhandlu wedolobha. Yizeke phela sazi ukuthi yena usebenza ngaphansi kweJPC. Ngakho lokhu ngempela udolobha kufanele lizikhulumele. Kodwa uthe uzokukhulumela ngenxa yokuthi uyazi ngakho ngaphambi kokuba idolobha lize likufake izicelo labathinta nabo njengeJPC ngakho uyazi kodwa abantu akade behamba phambili kulokho kube umnyango wezomthetho weCOJ yiwona othole lo myalelo ovela enkantolo. Lo myalelo ovela enkantolo uyachaza ukuthi uhlobo olunjani lamabhilidi abhekwa njengamabhilidi angekho esimweni esihle. Ufakazi uyachaza ukuthi uma ibhilidi linabantu abahlala kulona kodwa zingekho izitifiketi ngokwesibonelo izitifiketi esifakazela ukuthi ibhilidi liphephile isitifiketi esivela kunjiniyela ongalihlola ibhilidi bese ayibona ukuthi lisesimweni esihle, ibhilidi elinesitifiketi sokuthi uma kungaqubuka umlilo leli bhilidi lingakwazi ukuthi abantu bangalimali kulona. Ngakho zonke lezi zinto izitifiketi ezifunekayo. Uma lezo zitifiketi zingekho, lelo bhilidi libhekwa njengebhilidi elingekho esimweni esihle. Ibhilidi elinesitifiketi esifakazela ukuthi ugesi, amanzi asebenza kahle. Ngakho zonke lezo zinto kufanele zibe khona zigunyazwe. Kodwa uma zingekho lezo certificate lokho ke kusho ukuthi alisebenzi. Ngakho babe sebeya ngqo emiyalelweni wenkantolo, court order esikhulume ngayo eyangomhla ka14 November 2023. Base beqonda ngqo ukuthi iliphi elinye ibhilidi njengamanje umyalelo wenkantolo osukhiphile ngalo. Lelo bhilidi lase Wimbledon Court elapha ya ku 77 Wolmarans Street. Umthetho wenkantolo noma umyalelo wenkantolo usishilo ukuthi lelo bhilidi alikho esimweni esihle. Abantu abakulona kufanele baphume. Kodwa phakathi kwembandela ebekwa umyalelo wenkantolo ibale izinto ezintathu okufanele idolobha laseGoli lizenze ngaphambi kokuyokhipha laba abantu. Okokuqala, idolobha laseGoli kufanele lihambe liyoxoxisana nalabantu abahlala kuleli bhilidi lase Wimbledon Court. Okwesibili, lixoxe nabameleli balo abamelela labo bantu uma bekhona. Okwesithathu, libafunele indawo enye yokuhlala. Isizathu salokhu ummeli uyakuveza ukuthi uma phela ibhilidi sekuthiwa aliphephile, manje kushiwo ngoNovember lokhu, umyalelo wenkantolo uphume ngoNovember. Umbuzo manje ukuthi selenzeni idolobha? Zikhona yini izinyathelo selizithathile zokukhipha labantu abahlala kuleli dolobha ngoba selihlonzwe njengelingaphephile? Ilapho ke ingqinamba ababhekene nayo njengedolobha unkosazana Bothes ayishoyo ukuthi zifika lapho ziyime emthumeni bangazi ukuthi bazophuma kanjani. Okokuqala, umyalelo wenkantolo uthe kufanele bakhiphe abantu. Okwesibili, kufanele baxoxisane nabo ngaphambi kokuthi babakhiphe. Kufanele babafunele indawo. Manje idolobha alinayo indawo elizotholela abantu ukuthi bahlale kuyona. Lo myalelo wenkantolo uthi uma kuxoxwa nalabantu, laba bantu banelungelo lokusho ukuthi bafuna ukuhlala kuphi. Ingqinamba babhekene nayo ke njengedolobha. Yingakho ethi le myalelo yenkantolo ngezinye izikhathi mihle yona. Kodwa iyabanqinda ekutheni bakwazi ukuyilalela ngokusheshsha bayenze. Ngoba phela ukuyoxoxisana nabantu obakhipha kulelo bhilidi akuyona into engathatha izinsukwana. Labantu kufanele batholelwe indawo abazohlala kuyona. Lokho yaphecelezi okubizwe ngokuthi iTEA. Leyo ndawo iyesikhashana okuthiwa kufanele bahlale kuyona ngezimo eziphuthumayo awuveli nje ubabeke kuyona. Kufanele naleyo ndawo ibe namanzi, ibe nesimiso sokukhuculula indle uma behlala lapho. Manje iyona into efika ibabinde ke bangasazi ukuthi sizowulalela kanjani lo myalelo wenkantolo othi masikhiphe abantu sibafunele indawo yokuhlala. Ilento lokho eyiveza njalo njengoba engxoxweni yakhe echaza ukuthi ifika ibabambe. Kanti ke futhi umyalelo wenkantolo uthe uma ubafunela indawo kufanele ubase kuleyo ndawo ngemva kokuxoxisana nabo. Ushilo ukuthi abanye abantu abafuna ukusuka nje edolobheni. Bazothi asifuni ukusuka la. Sifuna nisifunele indawo la ngoba sihlala sisebenza khona la. Bese kuba nzima ke. Uze ukhala ngokuthi bekuyoba ngcono kuba umyalelo wenkantolo uyabavumela ukuthi laba bantu babathathe babasuse edolobheni bababeke kwenye indawo balilungisa ibhilidi bese belibuyisela. Yingakho manje engazi ukuthi lo myalelo wenkantolo uchaza njengokuthi uvela ubabophe izandla. Bangazi ukuthi bazowulalela kanjani ngoba wona usuphumile kodwa manje kunzima ukuthi uthobeleke ulandeleke. Uveze nokuthi abanye abantu abangena kulamabhilidi ngokungemthetho basuke benezinhloso zokuthi babekwe eqhulwini ngoba manje uma bephuma lapha ya sokufanele batholelwe kuqala indawo yokuhlala okuyinto futhi ke ebanzima ngezinye izikhathi bese babopha izandla emsebenzini wabo. Ngakho uvezile ke ukuthi kufanele uma betholelwa izindawo kwezinye izikhathi babekwe endaweni ezokwazi ukubanikeza i-transport kubize ngokuthi i-TOD lapho benikezwa khona ezokuthutha ezobaletha kalula edolobheni. Ngakho kuyo yonke ingxoxo yakhe ayivezile njengamanje ukuthi lo myalelo muhle umyalelo wenkantolo futhi uyasiza ukuthi kulungiswe amabhilidi. Kumane nje ingqinamba ababhekene nayo ukuthi akwazi ukwenzeka ngokusheshsha ngoba unalembandela yokuxoxisana phakathi kwedolobha kanye nabantu abasuke behlala ngokungemthetho kulelo bhilidi.
Thank you, sir. In closing, Ms. Botes, yes, you have highlighted the challenges, be it the provision of TAs and how your hands are hamstrung sometimes by others. But what assurance can you give the Commission about the measures and commitment by the City of Johannesburg to ensure that what happened on the 31st of August 2023 does not repeat itself? Or even your own closing remarks about the incident and the role of that JPC has played in this regard.
Yeah, I think I don't want to commit the city, but I think as a senior official in the city, we've all got a responsibility to ensure that we fix up the inner city and we fix it up ASAP. So I think holistically as the collective, we have to come up with a much more aggressive plan. And when I say aggressive, I'm talking in terms of timing, because, you know, Johannesburg is a city that attracts people into it. So the numbers in the inner city is only going to grow. They're not going to decrease. And I think as a collective, as a city, and being one of the administrative leaders in the city, we have to commit to fixing up this problem or finding a solution to the problem with all its challenges that we face. So where we, you know, how we engage the citizens within the inner city, it's probably best we show them the dangers they as citizens are facing and give them the assurance that once the inner city is fixed up, they are going to come back into it. And let a temporary emergency accommodation be just that, temporary. The only way as a city we can show them that it's temporary is by taking them out of the inner city, fixing up the inner city and bringing them back as fast as possible. But there has to be a plan that the city has to make public as to how they're going to fix up the city, how they're going to make it, turn it into not just a residential node, but a commercially viable node that serves its residents. Certainly as a senior official and as the HOD of JPC, I commit to that. The sooner we come up with a plan that the public can hold us accountable to, the safer we make the city for our residents. Thank you.
Thank you, Chair.
Thank you, Mr. Khoza. You may interpret that.
Thank you, Chair. Umbuzo wokugcina njengoba esegoqa ummeli uhola ubufakazi uthi isiphi isibophezelo noma ukuzibophezela bona njengedolobha abazibopha ngakho ukuze kungenzeki nanini kuphinde kwenzeke inhlekelele eyehla ngomhla ka-31st August 2023. Uphethike ngobufakazi ufakazi ukuthi uma esegoqa yize naye engasho ukuthi usebophela idolobha ogodweni ngokuthi asho konke lokho azokusho, kodwa njengesikhulu esiphezulu naye esinesandla kulokhu ucabanga ukuthi kufanele kuqhanyukwe nesu ngempela elizosiza idolobha ukuthi izinto ezifana nalezi ezenzeka nololukho kwenzeka ngomhla ka-31st August kungaphinde kwenzeke. Isizathu salokho ukuthi idolobha laseGoli liheha abantu abasuka yonke indawo. Ngakho kuyacaca ukuthi idolobha ngeke lime lisazolokhu liqhubeka landa abantu befika betheleka kulona. Ngakho manje bona njengomkhandlu wedolobha kufanele baqhamuke nesixazululo. Kodwa esinye sezixazululo ukuqwashisa umphakathi waseGoli ukuchazela ngezingozi zokuhlala ebhilidini elingekho esimweni esihle. Bese libachazela futhi umphakathi ukuthi akufanele unqabe uma utshelwa ukuthi uzothathwa uyokhoseliswa noma uyohlaliswa endaweni okwesikhashana. Uthe vele makube okwesikhashana ke bese bephinde bebuyiselwa lapho kade bekhona edolobheni. Ngakho uma umphakathi ukuqonda lokho ukuthi inhloso yokususwa kwesikhashana ukulungisa isimo bese uphinde ubuyiselwa, lokho kungawusiza. Ngakho ke uthi naye njengesikhulu esiphezulu kuleli dolobha neHOD ucabanga ukuthi naye uyazibophezela ekutheni bazoqhamuka nohlaka olusha oluzosiza luqwashisa umphakathi futhi lwenze ukuthi nezakhamuzi zaleli dolobha ziphephe futhi nezakhiwo zibe sesimweni esihle.
Chair, that concludes the evidence in chief of Ms. Botes. With your permission, I would like us to mark her statement COJ 5. Together with its annexures, of course.
Are you able to identify the annexure so that we can give them the supplementary COJ number?
Correct, Chair. Statement is COJ 5. And the first annexure will be COJ 5.1. Because there's an index that we have sent to the commission, but I think, for the purpose of the exhibit, I think the sales delivery agreement index. There is an index that was provided to the commission. Currently, from the first annex HB1 is the service delivery agreement.
That will be COJ 5.1.
5.1.
Yes.
And then HB2 being a copy. I'll just get to my statement quickly, because that's that document that was not part of the big bundle, being a copy of the property register. That will be COJ 5.2.
Yes.
HB3 being the book value of the property asset will be COJ 5.2. 5.3, my apologies, Chair. HB4 on a statement being the categories of the book value of assets will be COJ 5.4.
Yes.
HB5 being the asset register for Region 5 is COJ 5.5.
Yes.
The copy of the title deed, which was HB6, will be COJ 5.6.
Yes.
The copy, the rental, my apologies, the lease agreement is 5.7. HB8 being the payments schedule, 5.8. An assessment report prepared by the Department of Social Development referred to as HB 9 in the statement is COJ 5.9.
Yes,
Annexa HB 10 being a database of the occupants of Usindiso will be COJ 5.10.
yes,
The GFIS report, which was HB 11 in a statement, will be 5.11. Report referred to as HB 12 will be 5.12. The report on bad buildings, HB 13, will be 5.13. And lastly, because I admitted earlier on, it's no, that's it. Chair.
that's it. Okay, these are so admitted.
My apology, Chair, I've just been advised that the late entrance into the bundle being the court orders that were belatedly introduced into the record, that will be, in the entirety, that will be 5.13, 14.
14.
Is that time of day, Chair? So the numbers are not adding up because of.
Will that be all?
That's all, Chair.
Thank you. I think you may interpret Mr. Koza.
Excuse me, Chair. What? Caught me off guard.
I'm just joking, Mr. Koza. I think this would be an appropriate time to adjourn for lunch. We'll take a 50 minutes lunch adjournment.
Chair, can I just get some clarity with respect to the witness? Must the witness come back, or are there any issues that will still be raised with the witness? I just want to understand from a logistics point of view.
What?
Is the witness released, or will she come back?
No,
later on?
she's coming back.
Thank you, Chair.
There are still questions to be put to the witness.
Thank you, Chair.
Okay. Advocate Sminya.
Thank you, Chair. Mayor Buotes, good afternoon to you.
Good afternoon.
Ratamisha Muhumari Botes.
No amount of fiscal constraints can ever justify the death of 76 people and injury to scores of others. I must be right, eh?
Sorry, sir, I didn't get the last part.
I must be right to suggest to you that no fiscal constraints can ever justify the death of 76 people and the injury to scores of others.
Yes, you're correct.
I'm correct, yeah. And you see, the terms of reference are saying we must look at those who directly may be liable and responsible for that result. You know that too, right?
Mm-hmm.
You're saying, I don't know whether you agree.
Are you asking me if I know the terms of reference of this committee?
Yes, I'm saying the terms of reference require of this commission to determine those directly and indirectly responsible and liable for this tragedy. You know that.
Well, I've not read the terms of reference, but I'll take your word for it.
Okay. And to this day, I am correct to suggest to you there has been no acknowledgement by any level of government about this tragedy and whether or not it's even regrettable. Correct?
Well, I'm not sure, and I've not followed if government has acknowledged the tragedy, and if the city has acknowledged via the city's leadership the tragedy.
Isn't that my point, that somebody as senior as you stand, you are unaware of it? That's my point.
I can't respond to that, sir.
Sorry?
I cannot respond to that. I'm unaware of an acknowledgement, a public acknowledgement.
That's my point. You are not aware of it, right?
Well, I'm aware that the mayor had made some remarks in the media about how the city felt about the tragedy. So I think the city has acknowledged that it was a tragedy.
Okay. Now, you are aware at least of the legal instruments that explain even what you do, like the Municipal Finance Management Act. Correct?
Yes, I'm aware of the MFMA.
And in fact, your appointment is in terms of Section 93 of that Act, is it not?
Yes, sir.
And 96 of that Act would tell us that your responsibility with regard to the management of property rests with you. Am I right? You're the accounting officer.
I'm the accounting officer managing on behalf of the city's property, on behalf of them, in line with the STA, the business plan, and the budget which they allocate to me for the management of their property.
So whenever we see in the bylaws responsibilities of owner, we should read JPC in it.
You can't read JPC in isolation. You have to read JPC with the city of Johannesburg.
I don't know what you mean. I can't read JPC, which has, by law, as you say, has taken the responsibility to manage the properties.
Yes,
Is that a debate?
Sorry?
Is that a debate?
It is a debate, because JPC, if you recall, I said that JPC is given their mandate by the city in line with the STA and is funded 100% by the City of Johannesburg. So the implementation of those bylaws has to be funded by the City of Johannesburg via the annual funding plan. And if that funding is not there, then those bylaws or any other implementation of that property. So that's why I say that you can't see the two in isolation. The two have to go together.
You're making an admission, even though in a long way. It is the responsibility of JPC to manage these buildings.
It is the responsibility of JPC to manage the buildings in line with the STA and with support from the shareholder. If the shareholder does not give the support, then you can't manage the buildings.
Yeah, you're going there, but I'll show you why that doesn't help. Have you said that to the shareholder? I can't manage this building.
Yes,
You did?
yes.
And they said?
No, well, the shareholder continues. I mean, to change the JPC mandate, they will have, or to change JPC, they'll have to either give it its full funding, or they will have to integrate it back into the city via an institutional review. So the way we put it to the city is to manage your buildings, this is the funding we need.
Yeah, at least let me try and ask you to listen to my question. You tell me that the shareholder was made plain, that is the position. My next question is, what was the shareholder's response?
Well, the shareholder didn't give a direct response to say you can't manage the buildings, or you can't say that. The shareholder continued with the STA. So they didn't give a written response or a verbal response to say we disagree or not disagree, we agree or disagree with you. But I think the STA outlines that we're 100% owned by them. The property is owned by them. Hey. And it's the same scenario as your house. Hey. You get somebody to manage your house, you still have to give them the money for the maintenance and the securing of your house, and for paying the rates and the taxes of your house. They may be living in your house, but you have to give them the money to do that maintenance.
Mr. Interpreter, maybe we can go step by step.
Morena semenya o botšiša mabuta gore ke maswabi a magolo go lahlegelwa ke maphelo a batho ba 76 le bao ba gobetšego. Mohumagadi Botese o a dumela, o boa gape o mmotšiša gore na maikarabelo a se se diragetšego a magetleng a bomang. O boela gape o mmotšiša gore a o ile wa bala terms tšeo di laolago goba di sepelelanago le gore ge go diregetše taba ya mohuta mo ke mang a swantse go tšea maikarabelo le gore ba dumele gore se ke kotsi ye e seng ya tlwaelega go direga mo maphelong a rena. Gomme o re go yena ga ka bala sengwalwa se fela ke a tseba gore nna re swabišitše ke se se diragetšego. Gomme ratoropo wa rena o ile a tšea matsapa a go ka kgopela tshwarelo setšhabeng mo dikuranteng le go lemoša batho gore seo se diragetšego ka nnete se koša bohloko. Jwale a ge re eta mo tabeng tša semolao gona re reng dihlongwa tšeo di šomišwago mo tabeng ya gore bothata jo bo rarollwe bo se ke tlo ba diragala ka moso re fetša re dirileng. Jwale go na le section 93 eo e bolelang ka gore maikarabelo a boratoropo mo toropong maphelong a batho e reng
go be go tsenelele le ya section 96 e o ihlatholang gore wena mohumagadi voters o thwetswe ka tlase ga molawana wo gomme o ihlatholla ka gore STA business plan le budget ka mokana tsona dilo tse di kopanywa di dira gore re tšee maikarabelo ka seboka e seng motho ka o teng ka baka la gore se re se dirago re se dira re kopantšhitšwe ke seo re se emelago jwale ka teratoropo ga se taba ya gore JPC e lebelelwe e noši gore ke yona e swantse go tšea maikarabelo godimo ga se se diragetšego e swantse gore e tšewe jwale ka sehlopha jwale ka ga e boletše gore teratoropo STA business plan le thekgo ya ditšhelete ka mokana ga tsona le di-stakeholders ba swantse gore ba tšee maikarabelo a godimo ga seo se diragetšeng ge ba dutse ba tšwela pele ka taba ya maikarabelo a bona o botšišitše gore na a ge se se direga di-stakeholders ba kgatha tema mo tabeng e ba rileng ge le ba botša ka tiragalo ye a re aowa di-stakeholders ga di yake di atiša karabo ka mokgwa wa molomo goba di atiša karabo ka mokgwa wa go ngwala gore bona ba reng mo tabeng ye kwa mantšu a mang ga go ne karabo ye e tswilego godimo ga di-stakeholders
Shareholders.
Thank you, ke a leboga. Shareholders jwale a fa Mrs Botha a fa mohlala wa gore a re tšee mohlala wa gore o hirišeditše batho ntlo gore ba dule ka gare ga yona o swantse gore o ba fe mašeleng sa mathomo o swantse o ba fa taelo ya gore ngwako o swantse gore o hlokomele jwang o be ngwako o fiwe tšhireletšego o boe o ba fe tšhelete yeo e tlang go dira gore lapa le goba ngwako o hlokomelegege ya leboga.
Ma'am, I am trying very hard that my questions are fact-specific. And it doesn't help, give me examples about my house. Do you understand? Okay. Now, I want to invite you to look at one of the annexures to your statement, which is HB 9, and therefore exhibit, which is HB 9, COJ 9 it would be 5.9. Sorry?
Which file is it? Is it the annex?
It is the
file?
annexures 5.
And what page are this, Minya?
We are at page 113 of that document. Are you there?
Yes.
It would be a document arising out of the inspection during December of 2018. Am I right?
Yes.
And if you go to page 118, that's the last page. You would see the last bullet point under the recommendations is that the facility must be shut down.
Yes.
Never heeded, right, that recommendation?
No.
Sorry, I can't hear you.
No, it's not. We didn't shut down the facility.
I think there's something wrong with the microphone. You may repeat your response, Ms. Bottas.
No, we did not shut down the facility.
And you had the legal power for asking for the demolition of the building, didn't you?
No, we did not apply at this point in 2018 for the demolition of certificates. We did not do a structural assessment of the building at that point in time
No, the question is, you had the legal power to do so.
to demolish the building.
Yes.
No, I did not have the legal power to demolish the building.
I'm not saying I'm saying the city.
The City of Johannesburg, yes, after having done a structural assessment, then I'm not sure I understand the building, but if the city had the legal power, they'll have to follow, the planning department will have to issue that certificate to say demolish the building.
No, even if the building is inhabitable or not suitable for human habitation, it is a power for that building to be demolished. Am I wrong?
No, you're not wrong.
I know.
You're incorrect. You're correct.
Now, it's very difficult to resist an argument that says, had that happened, 76 lives would not have been lost and scores of other injuries averted. Very difficult, am I right?
Sorry, just repeat, if the building was demolished at that time in 2018,
Yes,
then scores of life would have been saved.
right.
Well, I can't answer that. I really can't, because I'm not sure in 2018 if the building could have been demolished or could it have been saved if it was structurally unsound, because in 2018 I did not have the structural engineer's report to say demolish the building.
You keep going there, ma'am, and I'm trying to have you accept that structural integrity that is compromised is just one ground on which a demolition can be authorized. Am I right?
I know a building can be saved if the structure's sound. A building can be saved. Hey,
And I'm
So
trying
the-
not to go to the structure.
so it does not have to be demolished.
Sorry?
So the building, if the building is structurally sound, it does not have to be demolished.
If it is not fit for human habitation,
If it is not fit for human habitation and it is structurally sound, you can get it fit for human habitation. You then have to find out what is wrong with the building to bring it up to a standard of to make it habitable.
you know, we know we're talking about Usindiso, we know we're talking about an assessment analysis that was done amongst others by yourselves. Am I right?
An assessment of the building in terms of, not from a structural point of view, but an assessment of all other requirements, such as the building being repaired, probably from an electrical point of view or from a plumbing point of view. So if you don't have to demolish the building if those repairs can be done on the building.
Were those repairs done?
No, those repairs were not done.
So why do you go there?
I thought you'd ask me to demolish, does the city have the power to demolish the building, unless I misunderstood your question.
I'll try again. There was legal power, having found the building not to be suitable for human habitation, amongst others, to have it demolished.
Then I'm not sure what that legal power is, because my understanding is that you would demolish the building if it's structurally unsound.
Okay. I'll move on. At no stage was Usindiso zoned for residential purposes. I must be right, eh?
Yes.
But that is not a fact without consequence in law. And I'm going to suggest to you that if it was ever designed for that purpose, a tragedy of this kind would not have happened. You want to debate that with me?
Well, I'm not sure that I can debate it with you. I'm really not sure I can debate it with you because it's been residential for a very long time. It's been used for residential purposes. I don't think the zoning is in play here because I think it's been used for residential for a very long time, JPC's formation.
And
So I
sorry.
really can't debate whether the rezoning caused the fire or the fact that the building was zoned industrial but used for residential purposes. It was used for residential purposes for a very long time.
I
And
know, ma'am.
therefore, it must have been suitable for residential purposes.
Morena Semenya o botšiša o hlatholla potšišo ka gore ke botšiša gore dipotšišo tša ka di a sepela thwi fela o ka re ga o di kwešiše gomme ke tla tšwela pele o mmotšiša gore o a kwešiša ba re ee o a kwešiša fela re tla tšwela pele ka gore re ke re lebeletse ditlaleletšwa e le go di-annexures re lebelele gore tsona di re rera di reng mo letlakaleng la 113 go na le setlaleletswa e le go annexure yeo e hlathollang gore go ile go ba le dinyakišišo tšeo di leng di a diragala ka December 2018 a dumela gore di le di a dirwa mo letlakaleng la 118 go ile go ba le kwanelo ya gore lefelo le swantse gore le tswalelwe wa dumela fela seo ga sa ka sa phethagala gore lefelo le tswalelwe potšišo ya tla gape ya re a molao wo filwe maatla a o ka phušula lefelo le ka baka la boemo jwa moago jwale wa hwetšagala gore o ba sa kwešiše gore a legal power e le go maatla a filwego gore a ka tšea magato godimo ga moago a šupa goreng a re ge nkebe e le gore boemo jwa lefelo le be le maemong a motho a ka dulang gona re ka se tšee maatla a go phušulwa fela ka baka la gore le se la phušulwa potšišo ya re gomme go ile go a tiragalo e bošula ya gore batho ba 76 ba hlokofala ba bang ba gobale ka taba ya gore ga se wa ke wa tšea maatla a semolao a gore o phušule lefelo le o re nka se kgone go e araba eo
Okay.
se ka be se sa diragala ka 2018 ge nke belela tšea magato a mohuta o re ga ke ka kgona go tšea magato a mohuta o ka ge ke be ke sena le dipego tša bo engineer le gore a lefelo le la hlwekiša goba la dirwa go ba kaone gore motho a kgone go dula go lona jwale petšong ya letšatši seo ga sa dirwa gomme re latlhegetšwe ke maphelo wena go o lebeletše lefelo le o bo bona gore motho a ka dula ka mogare ga lona aowa motho o be a sa tshwanela go ka dula ka mogare ga lefelo le ka baka la gore le be le santse gore le kaonafatše jwale re boela kua tabeng ya legal power gore na jwale ka ge wena o se ne bonnete jwa gore o bona le maatla ao a go ka thušolela lefelo le ge leago le be le agetswe gore e tla ba bodula batho goba e tla ba lefelo la kgwebo goba e be le lefelo la mohuta mang a re go ya ka tsebo ya gagwe o hweditše gore lefelo le agetswe gore batho ba dule ka mo gare ga lona ebile ke kgale go tsijwa ebile go bonwa gore lefelo le ga se lefelo la industry goba la kgwebo ke lefelo leo batho ba ka dulang ka gare ga lona.
Okay. Do I understand you, ma'am, to suggest that a building zoned for one purpose can be used for another?
So this particular building, as I've mentioned, was converted to residential ages ago. When I don't have the record of that. Okay. And ideally, the practical and ideal situation is that you should have your buildings and your properties rezoned for its effective use.
Yes, Mr. Interpreter, let's go step by step.
Potšišo e re a lefelo le ge wena o kwešiša ka ge o le molaodi wa tša meago le be le agetšwe go dula batho o re ga ke kgone go gopola gabotse gore e ka ba le ile la fetolelwa go tloga go industry go ya go la go dula batho neng fela se ke se tsebang ke gore lefelo le šomišetšwa gore batho ba dule ka gare ga lona.
2009, you took responsibility as the accounting officer. Am I right?
Yes?
Mr. Satane, you will interpret as he puts questions.
Yes, ma'am, thank you.
2009, you were the accounting officer.
That's correct.
The lease was still alive according to your understanding
That's correct.
until
Candidate Minya, let Mr. Satane interpret.
Ka 2009 o ile wa kgethwa go ba JBC o le an accountant o araba ka gore a boa gape a re kwanelo ya rena ya tumelano ya kontraka e be e sa phela wa dumela gore kwanelo ya rena ya kontraka e be e sa phela.
And just help me tidy this. What in law would have rendered it permissible for this building to be used as a residential building?
Ms. Portas?
Yes, ma'am, I'll just go ahead. It would have to meet, in terms of law, it would have to have met the requirements of as set out by the planning department for residential purposes. So the law would have been defined in the planning department. Now, if it could not have been used for residential purposes, the planning department would have stepped in ages ago and said that this building cannot be used for residential purposes.
Even as an accounting officer, you knew it did not have the certificate of occupation for residents. You knew that.
As the accounting officer, and you didn't have the certificate, you mean the rezoning for residential? It didn't have the rezoning for residential? I'm asking a clarity.
You knew in 2013,
Yes.
even then, that there is no certificate of occupation for residential purposes in respect of this building.
I did not have first-hand knowledge that this particular building did not have a certificate of occupation for residential purposes. I knew we had leased it out for residential purposes, but I did not look for an occupation certificate for residential purposes.
Potšišo e re molao go na le molao o laolago tša bodulo o bo tseba gore molao wo o gona ge o bo tšea maemo a gago mo tabeng ya JPC o re go ya ka theratoropo ge e be e lebeletše molao wo bo swantse ka botsentše tirišong gore taba ye e tle e kgone go tswela molaleng gore re filo molao wa gore lefelo le re ka le fetola gore e be lefelo la bodulo. Potšišong ya botšiše gore na a o bo tseba gore na go swantse go ba le certificate seo se go dumellang gore o ka fetolela lefelo le gore e be lefelo la bodulo gomme wena wa se ke wa e tšeela šetše a re ka ge a be a le mohlakiši kakaretšo wa tša ditšhelete ga sa ka latedišiša taba ya gore ga gona certificate se se ba dumellang gore ba šomiše lefelo le jwale ka bodulo ka ge e le gore go botse go saennwe tumellano ya go ka hiriša lefelo le.
Ma'am, I'm just not being personal, but we have to go through this. That's exactly why you qualify somebody as an accounting officer. Am I right?
Sorry, I don't understand the question. What would qualify somebody as accounting officer?
The title accounting officer says you must know whether the responsibilities of management of a building is done in accordance with the law. That's what the title places a responsibility on you.
And you're correct. And so when we entered into the lease agreement, we did it quite legally to say that this building has been used as a residential building, and therefore we're leasing it out as a residential building. We would never have leased it out because an industrial building, we would never have leased it out for an industrial building for residential purposes. It may have been zoned industrial, but it was converted at some point in its lifespan to residential. So we would have leased it out for residential purposes. So yes, as accounting officer, but there's 28,000 properties in that asset register. You say, sir, that you don't mean to be personal. Probably can't personally know every single property, but my manager said that this is residential and we're leasing it out for residential purposes, and along its lifespan and value chain, it must have converted to residential without the rezoning changing. And to do that, planning would never have given permission for the building to be occupied if it was not residential at some point in its life cycle.
Jwale ka molaodi wa tša ditšhelete o swanetse gore o tsebe ka maikarabelo a dilo tše di diragalago mo o šomang gona gore wa dumela gomme yena go ya ka tsebo ya gagwe o tseba lefelo le be le ka se kgone go fetolelwa go tloga go industrial go ya go residential ka ge e le gore mo dikwanelong ya bona ya tokise ga gone mo go hlaloswang gore lefelo le swanetše gore le fetolwe go tloga go industrial go ya go residential. Go na le meago e ka bang 28 manager wa ka 28,000, thank you. 28,000, my apology. 28,000 properties. Tše di leng gona tšeo molaodi wa toropo a swantše go tseba gore ge di swantše gore di beiwe leswa to rezone, go swantše go ba le dipoledišano tša go fetola mafelo a go a tloša mo a leng gona go a iša mafelong ao ba ratang gore a ye gona go swana le go tloša go industry o iša go residential. Wa raba ka tsela eo.
Ma'am, you seem to suggest that signing a lease agreement with Usindiso Ministry gave legality to this problem. Is that what you're contending for?
No. I'm suggesting that signing this lease agreement gave legality to us giving them occupation to a residential building. It may have been zoned industrial, but its use was residential. At the time of signing the lease agreement, in 2003, if you recall, I said I was not there in 2003, so I'm not sure what the state of the building was, but I'm comfortable that when they signed it in 2003, that this was a residential building.
ke tshepa gore ga o šišinye gore wena o tsenetše kopano le kgwerano ge bo saena lease go se go a lemogwa semolao se se tlamago kwanelo ye ya lena gomme o re se re be reng se filwe ke gore lefelo šele ka semolao gomme re ka kgona go hiriša lefelo le ge e le gore mohlomong mathomong a lwane e be le taba ya gore ke la industry fela go na le kwanelo e rego re ka le šomiša gore e be lefelo la mabulo se sengwe se se diragetše go fa ke gore tše ding tša dilo tše di diregile ka 2003 ke se ka be ka tsena mo mošomong mo go rialo ke gore go raya gore go na le dilo tše di diragetšego tšeo a sa di tsebeng mabapi le lefelo le.
May I suggest that that approach and attitude would be recklessly dangerous, and I'll explain why. The fire safety compliance for that building was never, ever proposed for residential purposes. Am I right?
I'm not aware of that, sir.
I beg your pardon?
I'm not aware that the fire and safety was not purposed for residential.
Ma'am, are you alive to the proceedings of this commission?
Yes?
And you know that there were shacks built inside that building?
Yes, I know that there were shacks.
And that there was evidence by fire officer that it was never capable of being used for residential purpose?
Sir, I'm aware there should never have been shacks inside the building. So the building was always used, to my knowledge, to the best of my knowledge, the building was used for residential purposes.
Ke lemoga mokgwa wa gago le boitshwaro jwa gago mabapi le poledišano ye ya rena e ntšhupa gore ga o gabotse o ka re ga o na le rena ka mo re šomang ka gona ka fa go tswele fire le safety department tšeo di hlatholotše gore lefelo le ga la lokela go ka dulega gomme karabo ya re nna ga ke tsebe seo ge a tswela pele o mabodo o re se ke se tsebago ko gore lefelo le be le loketše go dula batho potšišong e atla ya re a o bo tseba gore go na le mekhukhu ka mogare ga lefelo le karabo ya re ke a tseba ka go ba gona ga mekhukhu ye ka mo lefelong le ya leboga.
Yes, Mr. Silumedi.
Thank you, Chair. Madam Chair, Advocate Semenya is suggesting to a witness that there's been testimony before this commission that the fire mechanism in the building was not fit for residential purposes. I do not recall that evidence being made, and I please invite Mr. Semenya to put it to a witness to say which witness said the building fire mechanism was meant for industrial purposes and not for residential purposes.
Yes.
So that evidence was never, at least to the best of my knowledge, I do not recall that evidence ever being led, and Mr. Mayor just put to the witness that there's evidence that the fire mechanism was meant for industrial purposes, and that's not what I recall in this.
Yes, noted. Advocate Semenya.
The witness is Ntate Monageng. The witness is a fire chief. The witness says, even the barricading with iron steel could never have been compliant with that fire safety requirements for the building. That's not my point. There are two issues that are at play here. My colleague is saying this building was zoned industrial. The fire mechanism that is there is meant for industrial. So therefore, using it for residential, you are not using it for purpose for which it was intended. And he says, Monageng never testified that the fire mechanisms there was meant for industrial. That was not the evidence of Mr. Monageng. Indeed, he confirmed that if you look at how the tenants have reconfigured the building, it was not in line with what it was intended for. That I accept. But it's incorrect to put to a witness that was evidence-led that suggests that all the trimmings of that building was meant for industrial, not residential.
Yes.
Chair, let me avoid the phraseology of the question and still persist that there was never a stage in which that building was for fire safety purposes designed for residential purposes.
Ms. Portas?
I think the residents in occupation of that building for some time, and I've said it that they've been in that building for a long time. It was used for residential purposes, and I think if it was not, remember the building was built in some time ago, 1954. If I look at the deeds register, if it was not converted for residential purposes or was never used for residential purposes, at the point that it was used for residential purposes, the city's own departments would have inspected the building to make sure that it was fit for residential purposes. Otherwise, those building plans would never have been approved. So this building undergoes a lot of metamorphosis, especially when it is illegally occupied. Yes, the residents did put up shacks, and they did put up other iron structures that the city did not put up. So the city would never have given its approval from a planning point of view and a building control point of view, if I've got the right departments for residential purposes. We do know that when a building is constructed or used for any purposes, that the city departments have to give their respective approvals.
Mr. Tatane?
Ntate Semenya o sa tswela pele ka gore lefelo le le be le sa dumelelwa go ka ba lefelo leo batho ba ka dulang go lona o botšiša mohumadi bota gore lefelo le be le agetswe gore batho ba dule ka mo bothata e bile gore batho ba beng ba dula ka mo ba ile ba fetola sefahlego sa moago o ka mogare ba bang ba tsenya di-iron bars ba bang ba dira tše ba di dirago gomme seo ke sone se dira gore lefelo le seke la lebellega gore motho a ka kgona go dula ka gare ga lona ge teratoropo ya Gauteng e be e dira taba ya bona ya gore ba kaonafatše toropo ye ba ka be ba se ba dumelela gore lefelo le dumello gore le kaonafatše ka tlase ga mabaka ao ba beng ba nyakišiša ge ba hwetša lefelo le se la swanela gore motho a ka dula go lona teratoropo ke yona e beng ke re maikarabelo ya gore e re fe ditokelo tša gore lefelo le re le fetole le be lefelo leo batho ba ka dulang ka gare ga lona.
This conflagration was exacerbated by the fact that flammable materials were in there when the fire started. You can't quibble with that evidence, can you?
Chief, the flammable materials were in the building when the fire started, then it would not have been JPC or the city that would have put those flammable materials there. At the point that we were inspecting the building, there were no flammable buildings before the building was invaded. There was no flammable materials that was left there by JPC or the residents of the women and the children. So that flammable material that was found in the building must have been brought in after the building was invaded.
taba ye šoro e diragetse mo ko gore go bona le dilo tšeo di beng di tuka ga bonolo ka mogare a mongwe a gogo seo ke sešupo sa go bontšha gore lefelo le le be le se la hlokomelege ka gona ke ka mokgwa lefelo le le ileng la swa ke tšhišino yeo e filwego go mohumagadi voters o araba ka gore ge re be re fetle ka re seka lefelo le go bo go se ne le ditukiša tše di tukang ga bonolo ka mogare ga lefelo le ebile ga se JPS e beileng dilo tše tša go tuka ga bonolo ka mogare ga lefelo le rena la mafelo le ge re be re seka go ba re lekola lefelo le re hweditše go sena selo se se ka beng se šupa gore go na le ditlhotlheletše tša go tukiša mollo. Sorry, Chairperson, can I ask for a pen? My pen has just gone haywire. Thank you.
Ma'am, you didn't hear me say JPC was responsible for placing flammable material, did you?
No, I did not.
I still invite you, please stay to the question, and then we can go quicker.
Sorry, can you repeat the question?
I'm saying if you try as hard as I suggest you must to stick to the question that I'm asking, we might go quicker. Are we in agreement?
We're in agreement, sir, and I'm asking, can you repeat the question if I've answered it incorrectly?
No, I suspect. Let me go on. The enabling environment for the building of so many shacks on the ground floor was because of the design of the building. If it was properly residential, it could never have housed those shacks. Is that a fair statement to make?
Not entirely correct. There's a number of buildings where, even in residential, where they build within a room a number of shacks. That's the nature of the invasions taking place within the city. So sometimes one room is divided into 4 shacks where 4 different families live in one room. So it's not the design of the building. I think it's the nature of invasions that are happening.
Okay. I'm suggesting to you that if you have a space as open as this auditorium, it will enable invaders to be able to put the shacks that explain this hazard, this disaster. Is that too difficult to accept, ma'am?
No, it's not difficult to, it is difficult to accept, because when people invade a building, and we've seen it practically, we've seen it happen, when they invade the building, they do change. People are quite capable of breaking down walls and certain things in the building and changing the shape of the buildings inside. So it's not an unusual feature of an invaded building where people break things to create more space.
Lefelo le ka mokgwa le be le agile ka gona le go šupa gore le be le se la hlangwa la agwa ka tsela yeo le be le swantengong le agwe ka gona ke ka mokgwa re hwetšang go agilwe mekhukhu ye mentši ka mo gare ga moagogo ge a araba mohumagadi botse gore go na le meago e mengwe e swanago goba e agilwego go swana le ka le wo re bolelago ka gona fela ge re tla mo tabeng tša go tšea meago ka dikgoka mokgwa le tsela yeo batho ba ba tšeang mafelo ka dikgoka go dira gore go fetole sefahlego sa lefelo leo ba tsentšeng goba ba tseneng ka gare ga lona ka gore ga go nyakege gore e be lefelo le legolo go no nyakega fela sekhutlwana se ba ka kgonang go tsenya mekhukhu ba e tsenya ke mokgwa wa go tšea mafelo ka dikgoka gomme ore a wa dumela gore ga botsebotse moago wo o bo o se wa agwa ka tsela e leng gore o bo tlabe o kgona go thibela dilo tša mohuto ore
Okay, sorry.
batho ba go tšea meago ka dikgoka ba šomiša dilo tše ntši a re tšee mohlala wa ka mora e re leng ka gare ga yona gore yona e ka kgona go tšea mekhukhu e mekae karabo ya gage e rile ga go ne e taba gore ke sekhutlwana se se kakang ge ba ka no hwetša sekhutlwana fela sa gore ba tsene ba age mekhukhu ba tla eaga go sa kgathalelege gore na lefelo leo ke le le kakang ke le lennyane goba ke le legolo fela ba tla e tšea ka dikgoka.
You're not suggesting, are you, that hijacked buildings fall beyond the reach of the law? That's not what you're suggesting.
No, I'm not suggesting that hijacked buildings falls beyond the reach of the law.
As interpreter, let's go step by step.
Ka o rialo o šupa gore go tšewa ga mafelo goba meago e šitše le setlwaedi seo molao o sa kgoneng go se laola na ore aowa ga ke rialo.
So it must still be capable of government dealing with those issues. Am I right?
Sorry, so you faded there. It must be still capable of government, and then I didn't catch your last words.
Dealing with that invasion, as you call it.
Yes, governments, not just local government, provincial and local government, must have the capability to deal with any invasion or hijackings.
Yes.
Ka o rialo o ra gore mmušo wa gare le mmušo wa province ga bana maatla a go ka kgona go laola go tšewa ga mafelo ka dikgokanang ore aowa ga ke šišinye go rialo se ke se tseba gore mmušo wa gare mmušo wa province ba sa na le maatla a go ka laola go tšewa ga meago goba mafelo ka dikgoka.
Okay. There is something slightly perturbing in your evidence where you tell us that, okay, let me put it differently. I'm advised that the court orders that were referred to earlier were consent orders with the city agreeing those orders must be made. Do you know differently?
So are you saying that the court orders say that the city agrees those orders? Have I got the question right?
Consented to
The
those
city
orders.
consented to those orders, yes. From what I've read and seen, yes.
And it worries me if a senior official says, we consent to an order that is not implementable. I worry. Is my worry misplaced?
I think I must correct. I did not say that it's not implementable. I said it is difficult to implement with certain clauses that are there. It can be implemented. It will just take time to implement. I think those were my correct words.
Well, you even used that it's not a good order, but you must accept that if the difficulty of implementation were as you suggest, then you don't consent to such an order.
And I think that the best people to answer in terms of the consenting of the order would have to be the city legal department. Sorry ma'am, all I did was give my view. I think when I opened the statement, I said, I'm giving my view. I'm not the city, I'm JPC, but I am a senior official, and I expressed my view from an implementability point of view that it is difficult, it's doable, but it is going to take time.
Mr. Tsetsane?
ke tshwenywa ke gore ditaelo tše di filweng ke court, the city of Johannesburg e di amogetše. Wa dumela gore ee, ore ba di amogela jwang ba sa kgone go di phethagatša. Jwale ore nna ge ke le mo ke emela JPC fela city legal department ke yona e be e swantšeng gore e hlokomele gore go kwana ga rena go ba go dumella gore re tla dira se khoto e re se dire gomme se sa kgone go diragala ke bošaedi. Jwale ore nna ke arabela godimo ga seo ke se tsebang le gore ga ke na maatla a gore nka be ke arabela city legal department.
Okay. I understood you to tell us that the legal department consults you regarding matters of this kind. No?
The city's legal department would consult us in such cases, and I'll explain that consultation, is that do we have land available for TEAs? Are we able to source a structural engineer, etc.? And how are we able to assist with the making the land available should the city require to build TEAs? That's the consultation, and our responsibility as JPC would be to go and look for that land that is suitable.
Ma'am, I'm going to have to interrupt you.
Yeah,
We
sure.
never spoke about the vacant land.
I'm trying to give an explanation now what I meant, how they consult us. I think through you, Chair, I said, you asked the question, do they consult us? Yes, they do consult us. What do they consult us on? What land is available? Is there vacant land available? Is there buildings available? That's the consultation that takes place. They will also then, after they've negotiated the order, and they're best people to talk about the negotiation of that court order in terms of its implementability.
Kgoro ya tša molao ya theratoropo ya Gauteng e tle e boledišane le lena na ore ee re a boledišana. Jwale ore e boledišana jwang le lena go diregetše bošaedi jwa mohuta o ore rena ge re boledišana re le JPC re boledišana le kgoro ya tša molao ya tša theratoropo ya Gauteng re boledišana le bona ka naga ye leng gona le gore ba re nyakele di-engineera le go phethagatša TAE. Jwale potšišo e re o ka re ga o kwešiše dipotšišo tša ka mokgwa ke botšišitšeng ka gona. Karabo e re aowa nna ke go araba go ya ka mokgwa ke tsebang dipoledišwane tša rena di phethagala ka gona ge re kopane le ba legal department. Re boledišana ka tša eng? Re boledišana ka tša gore naga e gona mo re ka išang batho ba a go na le di-engineer tšeo di ka teng di a hlahloba lefelo le go phethagatša TAE jwale ka gare le GPS. Ge e tla mo tabeng ya semolao dipoledišano di be santse di lebišitšwe go legal department ya city of Johannesburg.
The question was, did you tell the legal department, hey, don't go down that road? That order is not capable of easy implementation. Did you tell them?
Well, by the time they brought the order, they'd negotiated the order already. So the order was handed over to us. So at no point during the negotiations was JPC involved. And so I would not know the terms of that negotiation until they come out of court.
So your answer is no.
Yes.
And maybe before I lead to another subject, you must appreciate that until there is an acknowledgement on the part of government where it may have erred, there will be repeatable events of this similar kind. Is that a fair statement to make?
Yes, there must be an acknowledgement from government.
And I worry too that the utterances of politicians who blame these problems on the courts may be a result of the functionaries in the department. You accept that?
No, I can't accept the utterances of politicians and what leads them to their utterances. I can't comment on that.
No, I'm going to invite you to comment, because if those utterances have no basis, it is your responsibility as senior management to go to them and say, oh, you can't go there.
But as, with due respect, sir, I can't comment or advise politicians what to say in public and what not to say in public.
No,
we can
ma'am.
give them the facts, and we give them the facts in report form, which is public documents, but what utterances they make in the public, it's political utterances. So I can't comment on that.
Mr. Tatani?
Ge legal department e be e tliša taba ya go lena le rileng go bona ge le kopana le taba e karabo ya ba gore rena ga re kgone go ka laela gore ge bona ba tsene ka kgorotshekong ba boledišana ka taba e re tsebe gore go diragalang se ba se dirileng gore ba re file taba e ba e kwanetseng le khoto ka yona ba re fa ka yona ka mantswe a mangwe rena ga re ne taolo godimo ga yona gore ba kwane jwang le kgorotsheko rena ga gone mo re tsenang gona re fiwa se re swantšeng gore se dira potšišo ere le swantše gore le amogele ka se se diragetseng o a dumela gore re swantše go ba re amogela kore ka mantswe a mare tšea maikarabelo a se se dirileng jwale o tswelela tšhišinyo goba polelo e rego borra dipolotiki ba na le go bolela ditaba tšeo e leng gore gantši ga di na maikarabelo ka mogare ga tšona tšeo di šušumetšago gore re fetse re ikhwetša re le mo re leng gona jwale madipoto gore nna ga ke ne taolo ebile ga ke kgone go ka ba botša gore ba reng se rena re se dirileng ke gore re ba file ditokomane tšeo di beng di amana le taba yeo gore ba di fetleke ba di lebelele ba di tsitsinkele gore ba ka re thuša jang go rarolola bothata jwa gomme ba feleletše ba šomiša sepolotiki godimo ga taba ya mohuta o.
Nobody suggested that you should give advice to politicians. Am I right?
Maybe I misunderstood your question, because I understood you said the utterance of politicians may be the results of the functionaries that support them. So maybe I understood it. But, and if I use the word advice, then I withdraw it. But I think I stand by the statement that I cannot comment on political utterances that politicians make.
ga se ke re di-politician di gapeletša go dira se re tshwanetseng go se diragale a ka o rialo o šišinya gore di-politician ke tsona di bulelang ka tsela e goba di šušumetšang gore ditaba di be ka tsela e gore ga ke kgone go swaya ka baka la gore ke mohlomong ga se ka kwešiša potsišo ya gago mohlomong phošo ya ka e ke dirileng ke ge ke re ba swantse go eletšwa gore ba bolele bjang goba ba dire eng fela nka se kgone go swaya godimo ga dipolelo tša borradipolotiki.
The court orders we mentioned a little earlier, none of them are suggesting that the TEAs must be in Region F.
Must be in?
Region F. Am I right?
Yes, I've read the court orders this morning. They don't mention Region F.
Because you seem to explain that the temporary emergency accommodation is hampered by the fact that you have no space in Region F. Did I understand your evidence correctly?
I've mentioned it, but I think you've understood me incorrectly. I said that the court order is just, there's a number of conversations in the court order, a number of clauses. It says that the city must consult with the residents of those particular blocks. I don't have them in front of me, but if I recall them, and that the city must provide TEAs. And I'm based on past experiences, and you are correct. The city can put its TEAs, and that's the conversation we have with the legal department. The city can ask us to look for a piece of land outside Region F. I merely expressed myself by saying that in engaging with the residents, their expectation would be, because that's what the court order said, the expectation would be that we provide them accommodation in close proximity to where they were.
In close proximity?
In close proximity, in other words, in Region F. So the court order doesn't say Region F, but it does say we must consult. And based on past experiences, that consultation with the residents would say that please provide us with TEAs close to where we live. And I was merely expressing what we can expect from that consultation that the city officials will have with the residents. But yes, the city can put the TEAs outside Region F.
The court order je ga go ne mo di bolelang ka TEA mo Region F. TEA mo Region F. Mo di bota wa dumela gore ga go ne mo court orders di bolelang ka TAF mo Region F. Fela gore re tle re kgone go rarolla bothata jo jwa batho ba TEA ke engwe ya ditsela tshepedišo tšeo re di šomišang go rarolla bothata ge re kopana le bothata ya batho ba ba swantse gore ba tloswe lefelong le lengwe ba išobe lefelong le lengwe gomme re swantse go boledišana le badudi ba ka maikemišetšo a gore ge re sa hwetše lefelo mo Region F re tšwele ka ntle re go kgopela lefelo mo re ka hwetšang lefelo re mo re ka ba beyang ka ntle ga Region F le ge e le gore TEA ga ya ke ya bolelwa mo di court ordering tše re bolelang ka tšona.
But that's precisely why the other paragraph to the order says, engage those that would be affected. Right?
Yes.
And in that engagement, you say to them, hey, I don't have a vacant land in the city. I can understand and appreciate your preference for being in the city. Isn't that the purpose of the order?
And that is correct, and that is why I said this morning that engagement, which will be run by the city manager's office and this human settlement department, the type of engagement they will have with the residents, is to pass that message on to them. Remember when I opened, I said, you know, the court order is for the city to answer, but as a senior official, I will try to assist. And yes, that engagement must happen. How long that engagement takes depends on the conversation between the city manager's office and the residents. And for the city manager's office to point out that we have found a vacant land or whatever we have found in a different region, and that's where we're going to set up the CEAs.
You insist in being long-winded unnecessarily. I'm saying the court order's purpose is that those people get engaged. And if the engagement goes that direction to say, I'm not able to accommodate you where you are. Is that purpose clear from the court order?
That purpose is clear from the court order.
And I'll give you the words you used in relation to this court orders, ma'am. You said, they make impossible court orders. That's the word you used. And I'm saying it must be irresponsible from somebody as senior as you are to ever mention a statement like it's an impossible court order.
No, Chair, I don't agree with that. I think I'd like to play the recording back to myself. I said it is a difficult court order, very, very difficult court order. Our hands are tied, but it's not a court order that we can't overcome. And I think if you play the recordings back, you would hear that. I said there is, but it's going to take time. And I gave a reason why it would take time. I never disrespected the court or the judgment. I said it's going to take time, and I think I explained why it's going to take time. But I'm not sure I used the word impossible without justifying why I used that word.
Hele tšea dipoledišano court order e rile go lena sepelang leng go boledišana le badudi ba lefelo leo wa dumela gore court order e rile jwale gomme seo se dirwa ke city manager gore a boledišane le batho ba ka seo kgorotsheko e se nyakang mabapi le taba tša bona tša go dula lefelong leo. Go tlatšišinyego e rego o šomišitše lentšu la gore ga go kgonagale goba ba tliša dilo tša go se kgonagale ore aowa ga se ka ke šomiša lentšu le la go se kgonagale mohlomong nkabe ga se ka ke šomiša lentšu le fela se ke se gopolang gabotse le ge le ka hlokomela dikgatišo tša mesong ya lehono ke rile go bothata ba re fa ditaelo tše bothata ka gore di tšea nako di nyaka gore di hlokomele di tsitsinkele gabotse di kwešišegale gore na felo fa go nyakega eng fela ga ke gopole ke nyatša di-court order ebile ga ke gopole ke šomišitše lentšu le ga go kgonagale.
The expression, these tie the city's hands, is court orders. Tie the city's hands. Did you use that expression?
I definitely use that expression.
And I'm saying that's my difficulty at this level. We ought to use a language that displays respect for how a democracy works, including what the courts say.
I think when I used the word tie the city's hands, it was not meant as a disrespect to the courts or to any judgment. I merely used that expression to show the difficulty that the city would have and the time. And I recalled using positive language as saying it ties the city's hands, but it's not unachievable. It's not something that we can't do. It just takes it's going to take some time to do. I think that's the way I contextualize my saying that it does tie the city's hands. But it was never meant to disrespect the democracy or the courts. That was never the intention.
o šomišitše lentšu le le rego re bofilwe goba re tlemilwe diatla ge ke le lebeliša le mpontšha go se hlomphe democracy le go se hlomphe tšona dikgorotsheko tša rena ge a raba mohumagadi bota o re aowa ke le šomišitšwe ka go bontšha gore ka mokgwa taba ye e leng ye boima ka gona ga re kgone le go šuta goba go lebelela ka thoko ka baka la gore re filwe taelo e rego le swantse go phetha ka tsela ya mohuta o gomme ge ke be ke šomiša lentšu le la gore re tlamilwe goba re bofilwe diatla ke be ke sa le šomiše ka mokgwa wa go nyatša democracy goba go nyatša dikgorotsheko tša rena ke be ke leka go hlatholla maemo ao re ikhwetšago re le ka tlase ga ona.
Ma'am, you can accept that I heard everything you said in your evidence in chief, even the qualifications. I'm complaining about the language that you are using.
Sir, I stand by my language that I've used.
Okay.
I pointed out the bureaucratic, maybe not so many words, but and I even pointed out that the court said that the buildings are not habitable. So within the confines of that statement, the city has to move fast.
Ke tshwenya ke polelo ye e šomišwa go fa mofumagadi Potese o re ke ema godimo ga polelo ye nna ke e šomišitšego ka baka la gore ge ke be ke e šomiša ke be ke leka go hlatholla gore teratoropo ke yona e swantšeng gore e hlokomele e gore ka mantšu a mangwe re ikhwetša re le mathateng a gore teratoropo e swantse go sepela ka lebelo la muta go phethagatša se se nyakang ke di-court order tša go tšwa kgorotshekong gomme ge ke šomiša language ya motong ke be ke leka go hlatholla gore re mo bothateng jwa gore re lebane le thaba ya taba gomme re swantse go šušitša thaba ye.
Now, I had intended to show you a battery of bylaws that were contravened, resulting in the tragedy. Please translate them.
Ke be ke ikemišeditše go laetša sengwalwa seo se akaretšago melawana yeo e ka bego e thibetše tiragalo ye ya masetlapelo.
Did I hear the concession correctly?
Oh, sorry.
She has not responded.
So
Advocate Siminya. You have not responded.
I thought he said that he intended showing me a battery of bylaws that were contravened.
And I asked, did you make that concession?
That bylaws were contravened?
Yes.
Yes, I did make that bylaws were contravened, yes.
And these bylaws places a responsibility on the owner of the building. Am I right?
Yes. Yes, it does.
Melawana ye ileng ya tshelwa e godimo ga molaodi wa lefelo le goba mong wa lefelo le gomme o a dumela gore ke nnete melawana ye e tshetšwego ye e godimo ga mong wa moago wo.
And there are bylaws that intend to avoid a number of hazards, including compromising fire safety. I must be right.
Just repeat that. There's a number of bylaws to
The-
avoid a hazard, including?
Fire safety bylaws,
Yes. Yes,
they're meant to protect life.
yes.
And their contravention cannot be lightly taken where the law places that obligation on an owner.
That's correct.
go na le melawana ya mollo le tšhireletšego yeo e ka beng re efogile kotsi ye ge nke be re ile ra e latela o a dumela gore ee e gona melawana yeo gomme melawana yeo e le ya tshelo.
Yeah, if we keep our answers that short, we're going to finish today. I appreciate your cooperation.
ke tshepa gore ge o ka tšea dikarabo tša go tša ba tše kopana re ka kgona go tšwela pele ka pele ra kgona go fetša.
And the purpose of a commission of inquiry by the Premier must be to investigate what actually happened and follow recommendations that are made. That's fair to say.
Is it fair to say that you must follow the recommendations? Sorry, just clarify your question.
The Premier's purpose for establishing this commission is inter alia, that there must be findings made, recommendations made to avoid a recurrence of this.
Yes, I agree with that.
tona ge a be a hlama komišene ye ya dinyakišišo tša tiragalo ye maikemišetšo e be e le gore go hwetšagale gabotse gore go diragetše eng go tliše diphetogo tšhišinong tšeo ka tšona di tlago go re lemoša le go thibela gore tiragalo ya mohutao e se ke ya boela ya direga o a dumela gore ee.
To achieve that purpose, the Commission must rely on its officials, on the city's officials, where they can help.
That's true.
Gore re kgone go hwetša thekgo gore re tle kgone go tšwela pele ka dinyakišišo tša taba ye baemedi le bahlankedi ba rena ba swantse go ba gona gore thuša gore mošomo o tšwele pele ka pela o a dumela gore ee.
And an approach that says you can mutate a building into a residential one, as happened here, you would accept a recommendation that discourages that approach to the law.
I don't understand the question.
I'm saying the recommendation must be to dissuade this attitude that a building can mutate from one use to another without following the consequences of that mutation, which is prescribed by the law.
Yes, a building cannot mutate without following the law.
Yes.
Yes.
And I heard your evidence in chief say part of rezoning problems are financial.
Yes, I say that.
And I want to suggest to you that it could never be good that to avoid that type of cost, we just change a building from one use to another.
Sorry, sir, just repeat that for clarity purposes.
I'm just suggesting that you can't complain if the report of this commission says you don't migrate a building from one use to another without following the law.
Yes, for a building to migrate, if you make a recommendation that the building must migrate, it must migrate within the laws.
Yes. And cost should not be part of the factors that helps you circumvent the provisions of the law.
But cost is a factor. Cost and budget is a major factor.
To help you circumvent the law.
Not to circumvent the
But
law.
that was
to-
my question.
yeah. No. No. Now, I can't accept that to bring the building, any building, not just this building, to its legal requirements, there is a cost involved.
ge re lebeletse taba ya go tloša moago goba go fetola go tloša maemong a leng mo gona go a iša maemong a o re nyakang gore a e gona ga re a swalanela go tshela goba go thulana le molao wa dumela mohumadi bona jwale re re diphetogo tšišinyo le ditšwetšopele tša khomišene ye e swanetse go go lemoša gore o ka se ke wa lebelela taba ya thekgo ya ditšhelete goba tšhelete o sa lebelele ditlamorago tša se se tlo go diragala ge o dirile ka tsela yeo ebile o sa hlokomele gore ka go dira jwalo o tshela molao ka gona thekgo ya ditšhelete ga se ntlha pele yeo re e lebelelang ge re fetola lefelo go tloga maemong a itšego go ya maemong a itšego mabota ga araba gore fela tšhelete e bohlokwa ebile ya nyakega ge re dire modiro wa motong.
Please accept from me that the constitutional right to shelter is one that the Constitution accepts. It is limited by the fiscal ability of the government to discharge.
If you don't mind my repeating, so I don't get confused, I must accept that the constitutional right to shelter is a constitutional that is limited by fiscal. If you can repeat that?
Yes, the Constitution only says, one, you have a right to shelter,
Yes,
but it also recognizes that governments don't have unlimited resources.
yes,
So it says it must be done within its fiscal means.
yes, I accept that.
Mo molaotheong wa rena go ngwadilwe gore motho o mongwe le mongwe le mongwe o na le tokelo ya go ka ba le lefelo la go dula gomme ke rata go šišinya go wena gore ge re lebeletse taba e ya bodulo mmušo o swantse go hlokomela gore maemo goba bokgoni jwa bona bo ka kgona gore ba phethagatše se fela ba se ke ba lebala gore se ba se dirang ke gore motho a be le mo a dulang gona ka ntle ga go tshela goba go fetola ye nngwe e re go motho o mongwe le o mongwe o swantse go ba le mo a dulang gona o a dumela.
So finally, one doesn't say budgetary constraints as though they are in themselves an excuse to escape your constitutional obligations.
And I think you've mentioned it in the previous sentence. Our constitutional obligation is to provide shelter, but it must be done within the fiscus. And if there's constraints, then we have to accept those constraints or find an alternative means around those constraints.
molaotheo wa rena o re ge re dira gore motho a be le mo a dulang gona gomme go na le tlhokomedišišo ya gore go na le thekgo ya ditšhelete ye e hlaelelago goba e sa fihlelelegego ga ra swanela go lebala gore molaotheo o re goba ga ra swanela go lebala gore bodulo bja motho bo bohlokwa ka gona ga ra swanela go fele re bolela ka taba ya thekgo ya ditšhelete goba tlhokego ya ditšhelete goba nyakego ya ditšhelete.
All I'm saying is the Supreme Law recognizes that all it depends on affordability.
That is correct, sir.
Se ke se bolelago ke gore ke re swantse go hlompha molaotheo wa rena gomme re swantse go lemoga re lebile re lebelediše gore ge re dira taba ye re se ke ra lebala le ge re hlaelelwa goba re senya yona tšhelete fela re se ke ra lebala taba ya gore kana mo re dira gore motho a be le bodulo.
Chairperson, those are the questions we have for the witness.
Thank you, Mr. Siminya. Ms. Sondo?
Can I have a comfort break, please? I need to go to the ladies.
Yes, I think this would be an appropriate time to adjourn for the day.
Okay.
Ms. Sondo?
I just have 2 questions on it, just to clarify.
We'll adjourn for 5 minutes.
Thank you for the indulgence,
Ms. Sondo?
Commissioners. Ms. Bottas, I just have 3 questions for you. The court orders that were referred to at page 193 and page 197, if you go and look at them, maybe just page at 1, you'll see that the applicant is the city. Are you telling the commission that you were not consulted before those applications were brought by the city as JPC?
In terms of, I'm not telling the commission that, in terms of the detail of those court orders and how they are drafted and the application that the city puts to the court, that's within the confines of the city's legal department. What the legal department would consult us on is there land available or buildings available that can be easily accessed. But the detail of what goes into the court order, that resides with the COJ legal department.
Are you able to share with the commission if you are consulted in these specific matters? The matters are in the bundle that was given to you.
Yes, if I may interpose, Ms. Sondo, are you consulted about the application papers which are before the court?
Thank you, Chairperson.
No, I'm not consulted about the application papers that are before the court.
So can we accept in this room that as a senior official in the city, you are telling us that an application brought by the city will be impossible for you to implement or difficult for you to implement?
No,
Let me rephrase.
I didn't say it's impossible, and I responded to the previous gentleman that I did not say it was impossible. Right? I said it can be implemented, and I think I was very positive in the way I phrased my sentence, and the recordings can be pulled out. I said that it can be implemented, it's going to take time because of certain things that have to be put in place. And I went back to the question that the court said the buildings are not habitable, and I explained from my experience what that means. Somebody says to you, and I even gave the example of office accommodation, but I never said it was impossible.
I apologize. That was my stretch, Chairperson. So we can accept that the city was not prepared before it approached the court to apply for those court orders, at least in relation to the provision of land and the provision of buildings.
The city's got land available. The city was prepared. They asked me, is there land available? There's always land available. We point to the asset register. In terms of the detail of that court order, I cannot say whether what gave rise to those negotiations or not. But I can make land available to the city. Getting that land ready, and I explained that getting that land ready, you'd have to ensure that there's certain infrastructure in place. That infrastructure does not happen overnight. I think I was at pains to explain that, because you agree with me, you have to put water, you have to put sanitation to make the land available, and that's why I said it's not impossible. It just can't happen overnight. It's got particular time frames attached to it, and those time frames must be worked out.
I completely accept that. The difficulty that I have is that these orders were not negotiated. The majority of them were not negotiated. They were sought specifically by the city. And so when you come and tell the commission that an application that the city sought, it is unable to meet, is a difficult conclusion to accept.
Now,
Yes, you may come, Mr. Sidumedi.
Thank you, Chair. I was a little bit patient with my colleague. I thought it's just seeking questions of clarification, but I think at the rate at which she's going, it's a cross-examination of the witness. And I think we have established day one that in the event that any of the colleagues want to cross-examine, it's not an automatic right. They need to apply to the chairperson for a cross-examination, and you must comply with the rules of this commission.
Yes, Mr. Sidumedi. Ms. Sondo, before I come in.
No, I want to apologize, Chairperson, if I've overstepped the bounds. I understood that I'm only given an opportunity to clarify the evidence already given by the witness.
Ms. Sidumedi, I did not get the impression that Ms. Sondo was cross-examining the witness. I think she's seeking clarifications, which Ms. Bottas has so far been able to do.
I mean, in the chairperson's sense in that regard, Chair.
Thank you. I will allow her.
Thank you, Chairperson.
I think you would need to repeat your last question.
So I was pointing out that since these are applications that are brought by the city, so the city has asked for these court orders, and they've been granted the orders basically for the asking. Is it then not unacceptable for us to have to accept that they went and applied and asked for those court orders without being prepared
And I think
to
when
implement them?
Sorry, Chair, I think when I started, when the court orders were put in front of me, I said that this was done by the city, and I'm going to try my best to assist. I once again say that in terms of the court orders and what the city applied for, that is the competency of the COJ legal department, and it is best that you ask them their whole thinking around those court orders
Thank you,
and
Ms.
their application. They're the best people, Chair, that can answer those applications, how they approach the court.
Thank you, Chairperson. I'm satisfied. The second question that I have for you, in relation to Usindiso, the Usindiso building that we are talking about here, at what time do you consider the building was invaded or hijacked? As JPC, at what time do you consider the building hijacked or invaded?
Sorry, at what time?
At what time? So a point in time, a date. So in your affidavit, there's references to different dates.
I think we said in December, if I can go to the affidavit, it was sometime in December that the building was invaded. We came back, we closed our offices on the 24th of December.
Which
And we-
year, Ms. Bottas?
Can I go
18.
to 2018, yeah?
Yes.
29. If I can go to my affidavit. And at that point, when we got back in December, the building was invaded. So it was invaded during that period that we were closed.
So do you accept then that at the time of the report, that's at page 113, the 30th of November 2018, the building was not invaded?
Can I go to that page?
Yes.
Which day was that? Which page is that?
So it's at page 113, that's when the report starts and goes to 119. I'm saying the report is dated 30 November 2018.
It was not invaded.
It was not invaded.
Yes.
Thank you. And then lastly, my last question, Ms. Bottas. In relation to the buildings that you manage, is JPC managing any temporary emergency accommodation buildings within Region F for the city of Joburg?
No. Temporary emergency accommodation buildings are managed by the Human Settlements Department in the city of Johannesburg, not JPC.
So you have no involvement with those buildings as JPC in any form?
In the management, no. What we would do is allocate space, be it a vacant stand or be it a building, we would allocate to them, and they would do the refurbishment and the management thereof.
Thank you, Chairperson. Those are my questions.
Thank you, Ms. Sondo. Ms. Sidumedi? Mr. Sidumedi? I almost changed your gender.
Thanks, Chair. Obviously, we'll request the Chair's indulgence for us to adjourn so that we can properly apply our mind on the issues that we will seek to re-examine Ms. Butter's on. And that will be
Yes.
done tomorrow morning.
These proceedings stand adjourned until tomorrow morning at 10 o'clock.